Lord, I seek leave of your lordship to file an appeal with the server copy applied for.
What is the date of the order?
23rd of March. Grateful.
Yes, leave granted.
My lord,
Same my lord, 23rd of March.
20, leave granted.
5th April.
Leave granted. Yes.
May I have your lordship's kind indulgence, my lord? Praying for leave to file an appeal without the certified copy. Order was of 27th of March. We applied on 30th of March.
Leave granted.
My lord, may I be permitted to mention, my lord, one mandamus appeal for inclusion, my lord? My lord, I have served on the other side, my lord.
Fresh matter.
Grateful, my lord.
Item number 762 of your monthly list, my lord. There is some urgency in the matter, my lord. My lord, by the impugned order, my lord, the respondent in the appeal, my lord, were directed to, my lord, construct boundary wall, my lord, with police help. Now, my lord, this boundary wall is being constructed at my property, my lord.
Then you file a civil suit, obtain an injunction.
My lord, so far as, my lord, the order of the writ court is concerned, my lord, pursuant to that order, my lord, they are constructing the boundary wall with
then
police.
you could have sought for reviewing the order passed with the writ.
My lord, contempt was filed by them, my lord, that contempt was also disposed, my lord. Kindly, my lord, here's the appeal, my lord, because, my lord, they are constructing the boundary wall in my portion of the property, my lord. And with the police help, my lord.
No. Did you file your affidavit in opposition to the writ petition?
No, my lord, affidavits are not called for, my lord.
Where you served?
My lord, we are served, my lord, we are represented, my lord, affidavits are not called for. Thereafter, my lord, order was passed, my lord, we preferred the appeal, my lord. Thereafter, my lord, they preferred.
Then what happened in the appeal?
My lord, appeal is pending before your lordship, my
It's a
lord.
fresh case.
My lord,
Why is it 700 and?
762 of the combined list, my lord.
Why it is going like that? Fresh cases won't come in the daily list. Why? No. That is wrong. That. No. How it can run in the monthly list? No. This is fresh matter should come up in the daily list.
The appeal was filed, my lord, in the midst of March, my lord. After 15th of March, it was filed, my lord.
Item number?
762, my lord.
See, if the matter has come up once and the other side has taken.
$762.
762.
Have you served notice upon the other side?
My lord, on the they were represented on the earlier occasion when the matter got adjourned, my lord.
So let it come up tomorrow in the daily list.
My lord.
Let us see.
My lord, may I have your lordship's kind leave, my lord, to mention, my lord.
Wednesday, it will come up on Wednesday.
Server notice upon the other side.
We shall.
Lord, my lord, may I have your lordship's kind leave, my lord, for upgradation of one matter, my lord, item 763. This is also, my lord, a fresh appeal. My lord, an interim order against an interim order, my lord, we have preferred an appeal before. My lord, my client is the airport authority. Now, my lord, the airport authority has floated a tender.
Wednesday, you inform them.
My lord, I have served.
May I, my lord, have your lordship's kind leave, my lord, pursuant to lordship's leave granted on last Monday, my lord, filed the appeal. My lord, thereafter on Thursday, I came up with your lordship, my lord, to mention this matter. Your lordship directed me to come today. My lord, the urgency before, my lord.
It's a fresh case.
It's a fresh case, my lord.
And what is the
Lord, the urgency is tomorrow. Lord,
whether it's group 4 or group.
It's not group 9.
Group 9.
Group 9. Lord, tomorrow is the date fixed, Lord, for the Honorable Single Bench. Lord, the Single Bench is proceeding in a manner. Lord, I have a forfeiture clause. Lord, the forfeiture clause has been stalled, and Lord, the Honorable Single Bench is proceeding in a manner so that, Lord, the forfeiture clause can be done away with, and whatever, Lord, damages I have suffered, I will be given that money, and things will be put to shut. Lord, under the law, that is, Lord, not the law. What is, Lord, I understand.
Tomorrow.
Lord, tomorrow is the date fixed, Lord. Any day, Lord, any time, Lord, that suits your lordship.
Wednesday,
Lord. Tomorrow is the date fixed, Lord. In the
What to do?
Lord, if tomorrow
to mention that matter before the Honorable Judge that we are fixing it on Wednesday.
Very. I am grateful.
Mention in the list, my lord, the 9 application. Fresh matter.
Fresh matter, yes.
What is a fresh matter?
All fresh matters you please hand over.
My lord, here the MAT appeal, the urgency is that there is a cost imposed upon us, my lord, by the single bench, my lord. I have preferred this appeal and a stay petition, my lord. May it be.
It's a fresh matter.
It's a fresh matter, my lord.
It has not come up earlier.
No, it has not come up earlier.
Then you give.
My lord,
Much obliged.
I like to mention it, PIL was there,
What is,
PIL, public interest litigation.
what is the urgency?
The building is being constructed on the road, some portion of the road
No, it will come.
is in post.
Is-
And
is-
my matter is in the monthly list, serial number 535. And I mentioned it earlier on 4th, and your lordship asked me to mention it today.
535.
Yeah, monthly list.
Let us see, sir, we have already got a couple of letters for upgradation.
Yeah.
All matters how it can be upgraded.
My lord, I mentioned it last week also. You
True,
asked me
sir,
to.
that is true, but we have got 700 matters running in the board. Can we upgrade all 700? You just think whether it is humanly possible.
No,
So
my
you
lord,
give
but
your letter, let us
sir,
see.
yeah, thank you.
And already we have received letters for upgradation.
May I to
Yes,
lordship kindly-
any other mentioning?
Thank you.
What is it?
My lord, a certified copy,
What is the date of the order?
5th April.
Yes, leave granted.
My lord, under compelling
Lordship.
circumstances, I'm mentioning this matter.
Upgradation.
Under upgradation item number 580, it's dealing with public money. I am a cooperative bank. The bank
You
election is
please
not
mention
clear.
next week. Please
My
mention.
lord, kindly,
Lordship.
bank
the,
will win, my lord.
With the leave of Justice Bhattacharya. Yes. Lordships, this is with regard to the mentioning that took place on the last date in the afternoon. With regard to the transfer of the criminal benches to the,
That will, this is not the public platform.
no, I am just saying that
Lordship.
we have filed a representation
You
from the members
inform
of
the
the bar.
secretary. This is a division bench we have started. The other day we had no other work.
Very well.
Please, thank you very much.
Your
You please
lordship.
hand over.
Madam, may I have permission to mention your lordship? My lord, there is a specific order of the my lords to me appear this matter on 27th of February. Thereafter, I handed over the listing slips as
You
per
give.
the routine, but it was not.
He says 27th it has to come. Please verify.
There's the order,
lordship.
from great.
Yes.
Your lordship, my matter is on today on item number 7, but my affidavit service and one supplementary affidavit has to be made. So could it be possible to,
Just can you wait for some time?
yes,
We are yet to call the list. It is item 7.
yes.
No, you
Your
please wait for 10 minutes. It will
Oh, yeah.
reach. Please be
Deeply
seated.
obliged, your lordship.
Please be
I'm
seated.
sorry for the.
One matter in the original side. That will have right fresh appeal. The past is without hearing me. Practically,
We don't have determination.
problem is, my lord, that the last two Hon'ble Justice Solicitor Division Bench did not sit. Lord, today also the list is.
You give the letter to my secretary, we will see. We don't have the determination there. Yes, sure. Yes, point out.
I have a great urgency matter of this matter, item number 588 of the monthly list. This urgency is to that extent, the economic structure of the bank is going to be destroyed. Now, the election has not been held due to inaction on the part of the election commission.
It's in the no objection.
If the matter is not be taken up within a week, the entire bank will be destroyed.
All right, you give. Please give.
I have given this name on last Monday, you lost to preserve.
True, sir. What to do? What to do? We sat at 10:30 for the past 10 minutes. Mentioning is going on. There are 700 matters running in the monthly list. Can we advance all 700?
Understand your lordship.
Therefore, we are trying to do our level best in the matter.
No, only I am
Unless
saying,
the
my lord,
pa-
I am giving this urgency,
You please.
taking that kindly, let it be taken
Sir.
into consideration. But if this
We-
matter is
we-
not being taken up,
No, each of the mentioning slip is placed before us. We examine the matter. If necessary, we take the file and then we'll do it. We can't be advancing everything.
I fully understand,
It's
but
been running
there are
in the
certain
list.
urgent matter which has to be taken up.
That's true, sir. We'll definitely take it out. You give the mentioning slip.
I am giving that kindly, let it take into consideration.
Milord, only one small request. Item number 104, it is related to one Devottar property, but due to heavy tension, this is going to create any type of riot that place.
Where riot is going to take place.
At the under police station, Panchkura East Mishnapur.
All right, you give a mentioning slip tomorrow. Let us see. Tomorrow, no mentioning, but you give the slip tomorrow. Yes, sir.
May I seek your lordship's indulgence, my lord? I mentioned this last week also, my lord.
What to do, sir? We are trying to advance. In fact,
This was-
last week, around 40 slips have come. Around 20 or 15 I have ticked, no? We have ticked, no? You give the letter, we'll see. You examine what upgradation.
No, this is not, this was in the list, but there was a direction for implementation of the scheme. Now, that scheme was launched, but that was not implemented, that's a contempt was filed. That's why the matter was delisted from this list. But it is a matter where the silicosis victim was.
Yes, you have given that. In fact, I have ticked that. We have ticked that. No, silicus. And where is that? Or when you will include upgradation area?
This was not in the list.
It was not in the list. He has given handwritten. Where are those mentioning slips? So what will you do with that? Take some action, no? Simply. Need to do, no? See, other day you said that you put a green tick mark. I put a green tick mark and given it. What have you done with that slip? Ask that to be included. But he has requisitioned the file from the department, let it come.
May I hand over it to one second?
Not required.
Your
Please
Lordship,
call the list.
Your Lordship, my Lord, this matter was admitted on 22nd February 2019.
Pardon?
22nd February 2019. This matter of West Bengal Taxation Tribunal is a dispute of incentive scheme of 4 crore 18 lakhs something. May I?
It's a group 4 appeal.
Yes.
What do you want? Inclusion?
Yeah. Yes. I would like to mention.
Original side matter.
What? No,
Is it an original side matter or
appellate side matter?
So 2 Fridays we don't have, no? This Friday also it's a holiday. Last Friday also is a holiday. So Friday we have to take it. Probably it can come only on 21st.
21st.
You give the slip.
May I? Oh.
Yes.
One new public interest litigation I filed few days earlier. Here the Pradhan of the concerned Gram Panchayat have awarded 16 tenders to his family members, which is not permissible in law.
Fresh matter.
Yes, madam.
My lord, may I be permitted to mention one, my lord, public interest litigation matter, my lord, for upgradation, my lord. My lord,
Upgradations. Please bear with us for a week or 10 days.
there is some urgency, my lord.
What
That's
to do? Every matter is urgent. See, today, this is our daily list. We have got 148 matters. Already 15 minutes has gone. Huh? Please, sir. Please call.
Appellate side daily list, serial number 1 and 2.
Made please, your lordship.
Yes.
Lord, by your lordship's last order, Lord, my lords, Lord, directed, Lord, the state, Lord, to take, Lord, assistance from, Lord, the.
Yes, yes. We directed some report to be filed.
Yes,
and
we
the
have,
report
my
to be
lord,
filed.
reports. My lord, all of them have not come in. My lord, most have, my lord, and my lord, I can tell your lordships, my lord, 2 facts, my lord, apropos this. My lord, 3 companies of, my lord, the Central Armed Police Force for acquisition. My lord, they were not available. So we got, my lord, Central Reserve Police Force. They were deployed. By and large, my lord, it was, my lord, peaceful. Only in one area, my lord, there was, my lord, a violation of the rally conditions. My lord, which was a part of, my lord, Hooghly district, which, my lord, Hooghly rural, which has, my lord, not, the report is yet to come in, which we shall, my lord, file, my lord, in due course. Otherwise, my lord, peaceful. My lord, no untoward, my lord, incident, my lord, happened. My lord, that's the information I have, and police station wise, my lord, I have, my lord, the reports which I, my lord, can.
But what about the other incident where investigation was?
My lord, we have, my lord, filed reports for that, my lord, on the last occasion. My lord, which your lordships have taken, my lord, already on. My lord, I have, my lord, several of them.
That was a bulky.
Yes, my lord, we have, my lord, filed those, my lord, last occasion. My lord, they were, my lord, to respond to those so that it could be, my lord.
Lord, may I have today's report from the London Advocate
What
General?
about the other report which they gave?
With regard to the other reports, not preliminary, not I have one submission before the lordship, not as per our information, not bombs, not including petrol bombs were hurled. But the police, Lord, has not added any sections with, because in the writ petition, our prayer was not for direct an investigation by NIA. Because under section 6 of the NIA Act, if not the exclusive acts are not included in the FIR, those are not investigated to be investigated by NIA. The state has conspicuously not included those
then
sections.
you do one thing. If you file your
Yes, I
exception
will
to
file
that,
an exception.
that
Exception.
report,
Exception
based
taking
on
all
that
the
we'll
reports.
take it up.
Yes. May I have today's report and will file a comprehensive exception on of all the reports?
Today's report concerns Hanuman Jayanti.
Yes,
Your
yes,
writ petition initially was for,
absolutely, ma'am. Absolutely, ma'am.
so we can ask AG to give a copy of
Yes,
these
yes,
reports.
Today's reports also, my lord,
Will
there
be
is no
given,
dis-
but you file a exception separate.
My lord, my lord, my lord.
Yes, ASG, let's say something.
The only thing which appears that not only in respect of the today's report, the earlier 4 reports have been filed. These exceptions are to be filed.
So you file your
Secondly-
exceptions. Let us see.
Secondly,
By-
I find on perusal of the writ petition and the allegation several they are therein, that there are several blasts.
Yes.
Once there is a blast, the law is attracted automatically to the National Investigation Agency Act 2008. And under section 6, subsection 5, it is also the central government's prerogative to take up the suo motu matter
Absolutely. That's my
in
prayer.
respect of investigation.
That's my prayer.
Therefore, if my laws direct us, then NIA should also thoroughly investigate. We are ready and willing.
my lord,
Because this is our absolute prerogative under section 6 of section 5.
Lord, my prayer was that the NIA should investigate and file a report because there have been
No.
not explosive substances which have been used in the Lord riot.
I have prepared a compilation, my lord, indicating, my lord, last few cases where orders have been passed by this honorable division bench, directive transfer of investigation, my lord, to NIA.
Yes.
Find, my lord, from
No, for that, Supreme Court says we have to record satisfaction. Why it needs to
my
be
lord, not correct, my lord, because the
transferred
purpose of
from
the
state
NIA
agency
Act,
to
my lord, there are 2 ways, my lord, that the central government steps in. My lord, the first is, my lord, the police officer investigating. If it finds, my lord, any of the scheduled offences, my lord, there is, my lord, a case for that. Then it, my lord, refers it to the state government. State government then forwards it to the central government. Then it's up to the central government after satisfying itself, my lord, that the purposes of the NIA Act require them, my lord, to do the investigation. My lord, they may keep or they may return. And my lord, second is, my lord, central government by itself, suo motu, provided that satisfaction is recorded, and my lord, there's evidence, can take it up suo motu.
But in the investigation or FAR.
No, my lord, nothing has, my lord, no bomb, my lord, we've, my lord,
That's
said,
our case from
my lord,
day
let
one.
them file, my lord, the affidavit, I'll
Bombs
explain
have
it.
been used.
I'll explain it, my lord.
apprise your lordship, my lord, why, my lord, I have submitted, my lord, the compilation of that. My lord, an appreciation, my lord, of the fact in each of the cases, my lord, it will be found, my lord, in some case, my lord, the explosives act, my lord, was inserted. Despite the honorable court finally returning to a conclusion that no, it is the Explosive Substances Act. The Explosives Act is basically primarily meant for licensing purposes of storing explosives. But in other cases, my lord, what has happened is, my lord, the Fire Safety Act was inserted, my lord, the Explosive Substances Act, my lord, the Scheduled Act was not inserted, my lord. In another case, my lord, there was a direct case, my lord, it got, my lord, the last took place sometimes in November. Now, finally, my lord, that is the last judgment, my lord. But the state kept on saying that no, there is nothing. Then finally, my lord, after the CFSL report, the state did not
Yes.
have any defense. Ultimately, it had to be transferred. So what is happening is, my lord, in each of these cases, my lord, going to the delay, but there are chances, my lord, that once the NIA takes over the investigation pursuant to exercise of, my lord, completion of exercise under section 6, my lord, but the investigation might, my lord, be prejudiced, my lord, owing to, my lord, lapse of time, my lord. My lord, that is exactly why, my lord, I was, my lord, troubling your lordship, my lord, with the compilation of judgment, my lord. My lord, there is another argument. Well, now, my lord, we have the reports, my lord. I'm grateful to the learned advocate general, my lord. The reports have been circulated, my lord. Now, we have gone through the reports, my lord. It transpires, my lord, that nothing has been said as regards, my lord, the bomb blast. My lord. There were categorical allegations that there were bomb blasts, my lord, as, my lord.
But there should be some material at least available.
What, my lord, I was suggesting, my lord. Now the reports are with us, my lord. My lord, section 3, subsection 3 of the NIA Act, my lord, that mandate that, my lord, the central government can take a decision on consideration of the report sent by the state, as also, my lord, information gathered from other sources. So, my lord, I understand, my lord, they are praying for time to file exception, my lord. In the meantime, my lord, if the central government can do that exercise and report it before the honorable court, my lord, what I was suggesting, my lord. I understand the learned, my learned ASG, my lord, will also, my lord, not be my lord, opposing my contention, my lord. Because ultimately, my lord, when it comes to us, the investigating agency, my lord, there is a lot of difficulty, my lord.
A lot of vital evidences, my lord, maybe, my lord, in the meantime, my lord, destroyed.
Apprehension of destruction.
In the
of
meantime, destruction of evidence. My lord,
Yes,
that's my
Lord,
prayer
after
from
exchange
day
of
one.
Response.
That's my prayer
Our
from day one.
response, and it is taken up after 2 weeks or 3 weeks.
Yes.
Now, what is the stage of the investigation?
My lord, we've indicated, my lord, all, my lord, in my lord, the previous affidavit which was filed, my lord, investigation has started. There have been arrests, 161 statements, 164 statements. My lord, there have been, my
Where is
lord,
that report?
there's a seizure list.
Report. No, not today's report. Last hearing they gave. Where is it?
And my lord, we were asked for, my lord, a report. My lord, on the basis of, my lord, the cases we had instituted, my lord, we have given that report. My lord, we want dealing, my lord, with every allegation in the writ petition.
We have no adversarial interest.
No. My lord,
The Commissioner of Police of Howrah, my lord, in paragraph 5, he says, my lord, that there was no permission, despite, my lord, a copy of the permission.
Lord, we have annexed all permissions in the supplementary affidavit. He says no permission.
Have also annexed it.
In the supplementary affidavit we filed.
That there was no permission. But as many as in 58 police stations, my lord, it is there in the report that there was internet suspension. And I find, my lord, my learned advocate general, my lord, apprising the honorable court that only 3 companies were requisitioned. So this shows, my lord, the efforts, my lord. Ultimately,
And Lord, one more.
responsible citizens, my lord, should all be, my lord, concerned about, my lord.
We just go through this.
And one more, my lord, interesting thing is, কোম্পানি গুলোকে ডিপ্লয় করেছে যেখানে কোনো প্রবলেম, যেখানে রায়ট হয়েছে সেখানে দেয়নি।
44.
Iron sandal.
They have not said it. In the original affidavit filed in the writ petition, there is a specific allegation that petrol bombs were hurled.
My lord, your lordship's absolutely right. But we have not dealt with, my lord, the averments made in the writ petition. Your lordships gave us 2 days time. We'll deal with it. Because, my lord, we gave a report, my lord, as to, my lord, what had happened, my lord, with regard to these. The status report, my lord.
But the report of the Howrah Police Commissionerate does not refer to that. It says some unruly, etc. See, report should be more concise. He has written, how many pages it runs to?
Let's say.
Lordships gave us, my lord, 2 days time to file an affidavit to, my lord, the writ
11
petition.
page
And your
report
lordships will, my lord,
40 page annexures. Total 53 pages. 54 pages. Praveen Tripathi, Lord Commissioner of Police, Howrah.
Because in the report at page 10, para 23, the commissioner says that further in the course of investigation, some incriminating articles like bamboo sticks, brickbats, damaged plywood, empty cold drink bottles, swords, bottle of acid, some broken glass, pen drives containing CCTV was also seized with investigating officer. Where is that 144 order?
my lord, my lord, kindly come to, my lord, page 50.
50.
50, my lord.
Of the report.
Of the report, my lord.
Uh, 51 both.
One aspect, my lord, if the order of asset is there, that will come also under section.
Yes, yes.
UAPI.
Unlawful. Yes, unlawful.
Of acid is coming within the definition of other chemicals under section 15 subsection 8. But I have a book on it.
NIA.
UAPI.
Oh. So Unlawful Activities Prevention Act is one of the schedule in the schedule. But suspending internet was a very serious issue.
It was, my lord. In fact, my lord, our country, my lord, as a whole,
Get that book.
my lord, has, my lord, the largest number, my lord, of, my lord, internet suspension. My lord, which, my lord, is not a, my lord, good sign at all. My lord, I accept that. But here your lordships will find, my lord.
You get this from the legend.
No.
using of bombs, dynamite, other explosives or inflammable substances, lethal weapons, poisonous, noxious gas or other chemicals.
Then-
Or by any other substance, whether biological, radioactive source.
It has to go to NIA.
But internet suspension has taken place when there is an external aggression or some infiltration can take place, etc. For a religious procession and because unless and until a sudden violence erupts, people are walking, somebody hits somebody, as a result, violent erupts. But reports prima facie show that they were all pre-planned. You cannot stop, like there was an allegation that pelting of stones took place from
Yes, yes.
the rooftops.
Rooftop.
Obviously, stones could not have been taken within 10 minutes, 15
Yes.
minutes for somebody to carry. So there must have been, therefore we in our order observed. that
Yes, your lordships observed that the intelligence. Possibly, my lord, that there was intelligence failure, my lord. Whether, my lord, that allegation is correct or not, my lord.
See, the problem is twofold. One is whether it is between two groups of people. The report proceeds on that line. There can be a third person.
People who just join in.
Who is not involved
at all,
but wants to take advantage of the situation. If that group is involved, then it requires an investigation by a central agency.
Fine.
That is very difficult for a state police to find out. Who has come in to take advantage? Probably there might have been little quarrel here, etc. going on. And somebody to instigate, like throwing some acid bottle or throwing some glass bottles, or according to them, throwing some petrol bombs. So it will be understood as if it is the other group which has incited this. So the infighting will start, but somebody would have set the fire, set the ball rolling. So to identify that outside source, unless a central agency comes, you can't do that.
Lord, may I just say one thing? The fact of the matter is that on perusal of the report which has been filed, this is delightfully silent about the steps taken by the police authorities in respect of a permission granted. Once permission is granted, what is the duty cast upon the police authorities? That is delightfully silent.
No, it's gone out of hands.
Yes.
That's admitted.
Secondly, my lord.
See, that's why the investigation is going on. They say around 36 people were arrested. They admit that swords, bottles, etc., bottles of acid, broken glass were all strewn. And as a,
then, my lord,
restriction on internet transmission and voice over internet telephony was restricted in some areas.
May I just read, my lord, once in the list, section 6, subsection 3.
But even as on today, police picketing is there? No.
My lord,
As on
different areas it's there, my lord, not in all areas. My lord, there are, my lord, two 144 orders. My lord, one with regard to internet suspension. Now, my lord, internet suspension, my lord, is no longer there. Now, my lord, with regard to assembly, my lord, there are, my lord, in some places it's continuing till today, the 10th, my lord, and my lord, in some places, my lord, it has been lifted.
Because the report proceeds to say deadly weapons, deadly weapons, deadly weapons. What are deadly weapons?
My lord, we've given it, my lord, in my lord, we've said, my lord, swords, my lord.
If firearms were carried,
my lord, firearms, hockey sticks, my lord, the swords. And the seizure list, your lordships will find, my lord, it talks about, my lord, what all, my lord, has been
petition. No, আমার নিয়ে নিস না বাবা।
In the report of the Superintendent of Police Islampur, he says that police personnel fired from non-lethal weapons like gas gun, stun grenade, etc. to disperse the mob. 37 rounds of plastic pellets were fired from anti-riot gun, 35 rounds of ammunition were fired from PAG, and 9 pieces of stun grenade were fired, 17 pieces of tear gas shells. Anybody was injured?
My lord, here, my lord, they have, my lord, given your lordship's looking at the first report, my lord, that's of 4th of April, 2023, my lord.
Where do you get the date?
My lord, page 11, my lord, your lordship might find the date.
Yes, that's where I read from page
Yes.
5 of that report.
Yes.
Then obviously the situation was very, very serious. Otherwise, 35 rounds of ammunition from PAG, 37 rounds of plastic pellets, 9 pieces of stun grenade, tear gas shells. Whether water cannon was used, no.
No, doesn't say so, my lord. And your lordships will find, my lord, at page 5. My lord, where your lordships
But,
reading, my
the
lord.
more the matter gets delayed,
Yes.
you cannot go to the root of the case. So all these, in fact, in the other report, 10 items have been seized. 2 hockey sticks, 1 broken thing, some 6 burnt motorcycles. And it's large scale rioting has taken place. If you see the seizure list, page 16 of the report of CID, Shivpur PS, 2 pieces sword, 3 pieces iron, 10 bamboo sticks, 15 broken bricks, 19 pieces empty cool drink bottle, 10 pieces empty alcohol bottle, 9 pieces of wooden lathi, 2 damaged traffic signal, 6 burnt motorcycles, 6 burnt Tata Ace, 6 vehicles, 1 school van half burnt, 4 pieces fully burnt condition, Tila. Tila marked as, what is Tila? THE? What is? Wheelbarrow. And report the type of incident which has occurred and seizure. There's
Lord,
no
one thing may I draw your lordship's attention. Page 11 of my writ petition, page 11, paragraph K. Lord, L, paragraph L, I'll beseech your lordships to read yourself. Lord, I don't want to read that. Kindly allow me to read paragraph K, last portion, last 6 lines. But kindly seize me not.
Wait. Paragraph.
First, kindly take page 10. Kindly take page 10. Or not, kindly take page 9 first. Page 9, para H. My lord has kindly got it. Lord, I have referred about the earlier riot, Lord, which took place in Mominpur and Iqbalpur.
No.
In the same manner.
Wait, sir. I am not able to get it.
Writ petition, page 9, para H.
Para H.
Para H.
Yes.
Page 9.
Yes.
But I have referred about the incident of rioting in Mominpur and Iqbalpur on the day of Kojagori Lakshmi Puja, Lord, of 2022, which had happened in similar manner. Lord, police kept a total silence. Lord, allowed Lord the mob to dismantle everything. Lord, riot took place. Lord, we have stated that. Kindly now take Lord page 10, para I. I have referred about the incident of Dalkhola, Uttar Dinajpur. Your lordship has seen the report. I have specifically referred about, my lord, that bombs were hurled. Page 10, para I. Then we will take paragraph 11.
But if bombs were hurled,
yes,
and there is a lot of reports in the media,
yes,
none of these 3 reports refers to it.
But why I have mentioned page 11, para K. I have mentioned
Speaking
that.
to AG.
Yes. Why?
None of these 3 reports refer to it.
My lord, we have, my lord.
That is true. You have not dealt with it para by
Yes, my
para.
lord, we have.
But a report by an investigating agency or by the commissioner or by the superintendent of police needs to place facts. That's all.
Correct. Absolutely.
You are here to maintain law and order.
Correct. We are only placing
And
facts.
you are not going to file an affidavit in opposition.
No,
to this.
correct.
So if that is
Now, my lord, kindly, my lord, let us start with, my lord, Islampur. My lord, your lordships were reading, my lord, page 5. My lord, kindly come to page 5. My lord, may I, my lord, make, my lord, 2 points of distinction here. My lord, one prayer, my lord, is that the matter should go to the National Investigating Agency because, my lord, these are scheduled offences And the central government should ultimately, my lord, decide whether, my lord, there should be, my lord, an investigation, my lord, by the National Investigating Agency. And the other prayer, my lord, was, my lord, for investigation to go to the Central Bureau of Investigation. My lord, on that, as of now, my lord, nothing, my lord, has been submitted. It's only, my lord, NIA. Now, my lord, kindly come to, my lord, page 5. Kindly see, my lord, your lordships read, my lord, about the seriousness, my lord, what happened. Your lordships, my lord, the first paragraph of page 5, your lordships have, my lord, read. Now, my lord, kindly come to, in the meantime, the agitated mob who were already carrying lathis to hold the flag, after becoming agitated, they started using the lathis for destructive purposes. The participants of the Ram Navami were also carrying swords and machetes, which they were forbidden to carry. Kindly note this. Even the members of other community were carrying swords, lathis and machetes to attack upon the Ram Navami procession, as well as police personnel on duty. Then, my lord, however, it is pertinent to note that acts of bombing and use of explosives as alleged by the petitioner and that the houses were set ablaze are not fact and totally baseless. Here the report specifically deals with, my lord, bombs. Second thing your lordships wanted to know, my lord, were with regard to injuries. My lord, kindly come to page 8. My lord, after, my lord, the situation, my lord, had been brought under control, and here there were 70,000 people odd, my lord, in that particular municipality area. Kindly come to para 6, page 6, last, my lord, 3 lines. After reaching officers and forces, took the disturbed area and performed route marches and continuous patrolling to bring the areas in normal. All the senior officers, along with participated in route march so-and-so. For stopping rumor, extensive miking was done in whole. During the unfortunate incident, persons of both the communities sustained injuries. However, one Jamshed Ansari so-and-so and attacked him, which as a result, he received grievous injury and still admitted in hospital in critical. Then para 7, unfortunately, due to stone pelting by agitated members of 14 police personnel, including superintendent of police, received head and bodily, also sustained a fracture in right arm index finger. These are, my lord, the injury suffered. Then, my lord, kindly come to para 8. These were, my lord, the provisions, my lord, under which, my lord, cases, my lord, were started. When your lordships had a query, my lord, on that day, my lord, with regard to normalcy, kindly come to para 14 at page 10. Here, my lord, internet, my lord, was not affected. Now, my lord, kindly come to page 11.
What is this iron sandals?
I have marked that also. Iron sandals.
Iron
Your
sandals,
lordships
chappals
looking
in
at-
door condition.
Yes, iron chappal. They
Iron
seized,
chappals.
they seized iron chappal, page 9.
We have seen sadhus wear wooden
My lord,
Perhaps they-
Adams.
Adams.
that
My
is
lord,
with reverence.
my lord, I had not
That too
noticed that,
in
my lord.
terms of iron chapels.
My lord, and my lord, my lord, could be a brand. My lord, I'm not aware, my lord, whether it's, my lord, a local brand or not, but it's certainly not iron because it couldn't be torn, my lord, otherwise.
Must be torn. Torn sandals.
Yes,
and
torn,
chappal.
my lord, it'll be torn.
It can't be iron.
Then, my lord, kindly take page 11, my lord.
All right, now you have arrested, 100 people, FIR has been lodged.
My lord, this is the first report. Now, and my lord, we've annexed also the medical reports, my lord, from page 23
Yes, sir,
onwards.
we saw that.
But my lord, I wanted to show your lordships, my lord, page 11 also. My lord, that's the last part of the report. My lord, 144, my lord, this is for unlawful assembly, was, my lord, in respect of, my lord, 5 wards. This report is of the 4th. Then there's a second report, my lord, which we've submitted today.
This one.
My lord, it's titled, my lord, report in compliance with order dated 5th April.
Whenever you receive it, you should write the date. And you have to write who gave it in pencil, AG. Otherwise, how we will know?
My lord, the last page, my lord, of this report, the annexure. My lord, the 144 order had been extended till, my lord, 8th of April.
But this appears to be a regular feature.
Absolutely.
In all religious.
Lord, Lord, in Kulagor in 2020, 2021.
Suppose it is
Kulagor
by
location.
the another community. They have also got these religious processions, etc. And every year it is like 6, 7, 8 incidents. And every time petitions are filed, courts are saying that in a central agency to take place. But how to ensure that?
My lord, your lordships gave an order, my lord, on the 5th to protect the citizen. My lord, it's worked.
It worked.
Yes.
But
So, my lord, we
then-
can make it, my lord, as my lord,
But
template, my lord.
No, correct. But then should it not be incident free? Should we not work to that?
Correct.
And this has not instilled fear in the minds of the righteous people. People who are writing the earlier orders of even NIA stepping in, it has not had an effect. 2022, he is getting paper orders. What has happened thereafter?
Gulagal also.
Iqbalpur used to be one of the most, my lord, charged up areas, my lord. After the NIA discover investigation, I understand, my lord, the state will also not be having any remarks, my lord, in so far as the investigation.
All right, sir, but then you have started investigation where?
We have submitted our charge, my lord. Mominpur and Iqbalpur were absolutely peaceful. So,
Then in this time, there is no incident.
No, this time there is no incident.
After your lordship's order, Ristra, another incident took place. Ristra. After
That
this
is
order.
true. The-
Ristra.
Ristra, we saw that incident.
And after
But
the
then
order,
there
after
should
your
be
lordship's
some
order,
way
they
of,
failed to protect the citizen. Failed to
because I-
protect. Regular feature it is.
Speaking for myself, I dealt with such matters, but over a period of time, things improve. And thereafter, nobody came to the court. It's all with the Commissioner of Police or the Director General. He issues a circular. The respect to Superintendent of Police, or if it is a city area commissionerate, the Commissioner of Police issued directions. Of course, there may be one or two incidents here and there, which will be handled by the local police. And year after year and days after days, we are sitting here and
Absolutely.
there should be something. And if NIA stepped in investigation, those two areas are districts,
Yes.
or not districts, areas, is it?
Areas.
Areas in a district.
In Calcutta. It's in Calcutta.
More or less, my lord, after the last Lakshmi Puja incident, my lord, that the riot that broke out, my lord, after the NIA took over, my lord, Calcutta was more or less peaceful this time, during the Ram Navami, I understand.
Lord, we had seen riot in Saraswati Puja, in this Dhulagor and Uluberia. Then Lakshmi Puja in Myominpur, Khidirpur, Ram Navami in Howrah, Risra. Now, this all happening, Lord, with greatest of respect, Lord, without hurting anybody's sentiment. Lord, it's all happening whenever there is not a Hindu festival. Whenever there is a Hindu
But
festival.
what about other festivals?
Nothing. There is no riot in Mohram. There is no riot in Mohram. This has become a regular feature in Bengal.
But they also have this procession.
Yes, but nobody disturbs them. Lord, I kindly read paragraph, page 11, paragraph K of my petition. Everything will be cleared. Why this is happening? I don't want to read it openly. Kindly read it. Page 11, paragraph I. Read petition. Why this has happened? Kindly read it yourself.
Page 11 is.
Page 11, paragraph I. L.
Yeah.
Last paragraph. L. I mistook it as I. L. আমি কাউকে পার্টি করে বলছি this may be a reason.
And where is this statement, alleged statement? It is annexure,
Not kindly, Lord.
newspaper statement, is it?
Kindly give me a second, Lord. Page 53, my lord, may read it yourself, Lord.
It's not the statement.
Not that, we have said not what we got from this thing. But this, Lord, I am not blaming anybody. But this is happening, Lord, in Bengal. In last few years, this has become. Earlier, this was not there. So, Lord, investigation by an independent agency is required.
All right, we have seen the report. You have made your submissions. That will be your exceptions.
My item is item number 10. Kindly tag with item number 1 and 2, your lordship. And this is my affidavit of service.
But if my lord allows us, we can
Affidavit of
also come
service.
back with a written lord exception.
I don't kindly appreciate that. But as far as the report of the Commissioner of Police, Chandanagar Commissioner is concerned, my lord. Number it deals extensively, my lord, with what happened during with the railways. So there is an
Which is that report? Which is the report you are referring?
This is the report by one Mr. Amit P. Javalgi, Commissioner of Police, Chandanagar Commissioner. Report on behalf of Commissioner of Police, Chandanagar Police Commissioner. It was signed on the 4th of April, my lord. I will not say it has been affirmed. None of the reports are in fact affirmed, my lord.
Not required, no?
Yes, it was signed
Once
on
it
the-
is affirmation, it becomes affidavit in opposition.
It was signed on the 4th of April.
Yes, we got that.
Now, my lord, paragraph 3 at page 4 of this particular report deals with, my lord, what happened with the railway services. My lord, railway services, my lord, were suspended. We also saw the statement of the Chief Public Relations Officer of the Eastern Railway that we cannot operate the railways now. That was the situation, my lord. So now it has been stated that it is to be mentioned the last two lines, my lord. I will not take much time. Paragraph 3, the last two lines, it is to be mentioned there that there was a news on various news portals that miscreants stopped the train services. In this regard, it is brought to the notice that violence erupted
No,
again
it's,
on 3rd April.
we don't have that.
My lord, there are two reports,
my
my
lord,
lord, of
I take-
4th of April.
Whereas Mr. Bhattacharya is referring to this copy, my lord, may have
আচ্ছা,
it.
We
আচ্ছা,
should
ওখানে
have
আছে,
one.
সব আছে,
আছে?
সব আছে।
Find out, ask him which is the, take this and find out.
এটা একবার দাও জোসেফ কে তো।
No, we should have a copy of that, no?
We had
Who
given,
is the,
my lord, Amit P. Javalgai, my lord. কোন প্যারা দেখছো তুমি?
Which four paragraphs?
yes.
I was referring to, my lord, paragraph 3 and page 4. Last two lines, my lord, at the bottom, my lord.
Why two reports on the same date, sir?
My lord, that
Oh,
was
this is
added,
fourth.
yes, my lord.
This is 4th April. Page 3.
Page 3, my lord, page 4, paragraph 3. Error starts with further on 3/4/2020.
Yes.
Yes. But I will be, my lord, just reading out, my lord, the last two lines, my lord. It is to be mentioned here that there was a news on various news portals that miscreants stopped the train services. In this regard, it is brought to notice that violence erupted again on 3rd of April 2023 evening at many places, including 4-number railway gates. One vehicle of Mr. Frontier Rifle Sharua was stopped by the miscreants near the railway crossing and put on fire. The burning vehicle touched the automated drop gate, which got struck and led distress signal. Railway authorities reached the spot and converted the barrier into manual handling. So train services were suspended temporarily to maintain the automated barrier. Shortly, vehicle was removed away. Train services resumed shortly. As informed by railway authorities, there was absolutely no damage at railway station or of railway property. My lord, I was referring to this, my lord. My lord, why, my lord? Because, my lord, as I was suggesting, my lord, my lord's kind sanction. But that the other sources, as contained in section 6, subsection 3 of the NIA Act, my lord, this will cover, my lord, once the central government is directed to file a report before your lordship. But the information from the railway authorities can also be taken, my lord. These all come under the central government. And a comprehensive report, my lord, appreciating, my lord, what happened, for how long there was stoppage or suspension in train services, whether any property has been damaged or not, because police cannot apprise that, my lord, to your lordship, my lord. But this is one aspect, my lord. And my lord, the other is, my lord, the situation as I find, my lord, in the report, paragraph 5, it has been stated that there was, my lord, a large pre-planned attack, which was there with firearms and all, my lord, kill the police personnel.
Where do they say that?
This is there in page 6, paragraph 5. But 7 lines.
Yes. Assault the police personnel with bamboo sticks, iron rods, so and so, displaying swords and firearms, the view to kill the police.
There, my lord. Another aspect, my lord, be indicated, my lord.
As a result, many police personnel received bleeding injuries. Police team tactfully handled the situation. And those police personnel have been given treatment and they are all fine. But in this Rishra police station, Arms Act, one of the offences under the Arms Act has been reached. When was this Lakshmi Puja?
Was sometimes in, my lord,
October 2022. Lord,
and what happened to the university?
Handed up the compilation of judgments, my lord, that I handed up, that contains the order, my lord.
Of Khidirpur, Bombay. No,
which is that serial number?
You will find it is, my lord, serial number 3. But I have prepared, my lord, an index, my lord. Serial number 3 pertains to my lord Nobel Kumar Bandyopadhyay. But 2 and 3.
এই নীলাদ্রি সাহাটা তো রিটে অ্যানেক্স করেছে রিটে
From page 19, my lord, of the compilation.
One second, violence.
But in that incident, case was registered under the Explosive Substances Act.
Case was registered under the Act, but in other cases, my lord, as there is compilation.
But the report is silent about that allegation.
One more thing, my lord. Come into your lordship, the report pertaining to my lord, the incident at Risha is that once your lordship, my lord, finishes, my lord, using the compilation. My lord, kindly, my lord, take for once page 12, my lord, of that particular report, my lord, pertaining, my lord,
Page 12.
Page 12. I'll just indicate, my lord, what has been done, my lord. It is, my lord, apparent, my lord. What has been done, my lord?
Page 12 is seizure list.
Yes, my lord, kindly seize, my lord, against serial number 5, my lord, how the seizure has been made, my lord. Initially, my lord, this was, my lord, signed, my lord. Thereafter, my lord, the seized articles have been, my lord, consciously filled up. My lord, will find against serial number 5, Roman 5 has been kept blank. But kindly mark it, my lord.
Page?
Page 12 is a list.
But that we have already expressed to AG with so much of damage, etc. 2 hockey sticks, three.
Kindly take note also, my lord, of the, my lord, seizure list. The time of seizure, my lord. It seems, my lord, that something Herculean has been done. It starts, my lord, multiple seizure lists according to the same.
2150 hours to 2205 hours.
Kindly take the next seizure list. That is, my lord, 21.5 to 21.25. Thereafter, my lord, the next seizure list, 2035 to 2055. Thereafter, 1945 to 2025. Lastly, my lord, 2130 to 2145. My lord, we can well understand, my lord, how, my lord, these seizure lists have been prepared, my lord, without even a pause of a minute, my lord.
Prepared by the same person.
By the same person, my lord, one after the other.
Same person.
This indicates, my lord, what has been seized and how it has been seized. But these are all, my lord, doubts, my lord, which occur to the any person of, my lord, my lord.
Only one seizure list, page 14 is by a different person, but 12, 13, 15, 16, all by same person. But apropos to what Mr. Bhattacharya said, kindly seize the place of seizure. Not they are at a very much distance from one to another. How could she reach from one place to another place? Superwoman. All are office work. The superwoman clearly.
These are all, my lord, seem to be, my lord. There can arise a doubt in the mind of any person of ordinary students, my lord, that seem to be, my lord, cyclostyle mechanical scissors.
Lord, page 12 is on the road of inner road, local area. 13 is Bada Bazar Inner Road. Then 15 is Bada Masjid White GT Road. Then 16 is collected and seized from local road of Batagoli under Isra. Same person, same time. How could she be at?
And how far are these
Lord,
places?
I come from somewhere near to that. Lord, they are Lord at 15-20 minutes distance from each other. And when a riot is taking place, must have taken more time for them to reach. How could she be there all everywhere, Lord, at the same time? No investigation, nothing.
Nothing but office work.
Let's see.
And I was.
Lord, this has to be transferred to Lord NI.
All right, we'll consider.
My lord, may I, my lord, respond to my lord? I was getting a bit confused who's the petitioner, my lord, because my lord, they seem to be from both sides. So my lord, only on a question of law, my lord, I want to, my lord, address your lordships. Facts are there, my lord, before your lordships. And my lord, the seizure list, your lordships will kindly notice the camps, my lord, from where it has happened, which is at the bottom right hand. Now, my lord, kindly take, my lord, section 6, my lord, of, my lord, the act, my lord, the NIA Act.
Yes.
On receipt of information and recording thereof under section 154 of the code relating to any scheduled offense, the officer in charge of the police station shall forward the report to the state government forthwith. So, my lord, on receipt of information and recording under 154. My lord, if a scheduled offense, my lord, is, my lord, mentioned, then, my lord, it is given forwarded with a report to the state government. 2, on receipt of report under subsection 1, the state government shall forward the report to the central government as expeditiously as possible. Then 3, my lord, on receipt of report from the state government, the central government shall determine on the basis of information made available by the state government or received from other sources within 15 days from date of receipt of the report, whether the offense is a scheduled offense or not, and also whether, having regard to the gravity of the offense and other relevant factors, it is a fit case to be investigated by the agency. So, my lord, this is the first aspect. 6.1, 6.2, 6.3 is a procedure, my lord, which starts from the police station itself. My lord, it travels up to the state, then, my lord, from state to central government. Condition, my lord, is, my lord, a scheduled offense, my lord, needs to be, my lord, mentioned. This is, my lord, one aspect of the matter. And, my lord, the decision making that the central government can do, it has to be done within 15 days on the basis of the report and whatever information, my lord, they have from other sources. Now, my lord, comes, my lord, subsection 4. Where the central government is, I'm sorry, my lord, 5. My lord, 4 is, my lord, consequential. Kindly come to 5. Notwithstanding anything contained in this section, if the central government is of the opinion that a scheduled offense has been committed, which is required to be investigated under this act, it may so moto direct the agency to investigate the offense. So, my lord, one is, my lord, initiated, my lord, from, my lord, the police station. One is, my lord, a so moto power, my lord, which is, my lord, provided. Now, my lord, for an exercise of a so moto power, my lord, blessings of the court are not required. Now, my lord, all the cases, my lord, which have been cited before your lordships, my lord, were a case, my lord, where, my lord, a scheduled offense, my lord, had been disclosed, my lord, in, my lord, the 154 report itself. All the cases. Now, my lord, after that had been done, your lordships will find, my lord, my submissions, my lord, have been recorded. That, my lord, under 1, it will come to the state. Then, my lord, state under 2 will forward it to the central government, and central government, my lord, will, my lord, then decide, my lord, whether, my lord, this is a case of NIA or not. My lord, that is number 1. Now, my lord, number 2, kindly have a look at the schedule. Yes. My lord, under, my lord, section 2, subsection 1F, my lord, Your Lordship will find, my lord, the definition of schedule is scheduled to this act. Now, my lord, kindly come to the, my lord, scheduled offences. My lord, the Explosive Substances Act. Lordship, my lord, this is, my lord, absent here. Atomic Energy Act, Unlawful Activities Prevention Act, all, my lord, not there. Now, my lord, Anti-Hijacking Act, Suppression of Unlawful, SARC Convention, so and so, weapons of mass destruction and their delivery, and offences under. My lord, kindly see, kindly come to, my lord, also, my lord, Arms Act, because your lordship said, my lord, Arms Act is subsection 1AA of section 25, chapter 5 of the Arms Act. It is, my lord, that particular offence. My lord, if it is not, my lord, the report, my lord, does not show, my lord, that, my lord, that there is a duty cast, my lord, on the police officer to forward it to the state for onward transmission. Now, my lord, one case I wish to cite. My lord, apropos this, my lord, there was a decision, there was a challenge, my lord, to the provisions, my lord, of this act. My lord, it came up, my lord, before, my lord, the division bench. My lord, I'll just, my lord, this is impossible. Tomra kyun mone rakhbe na? My lord, I'll hand up a second copy, my lord, kindly, my lord, your lordship, kindly, my lord, take, my lord, the decision reported in 2013 SCC Online Bombay 1354. My lord, the vires, my lord, of the act, my lord, had been challenged. Now, my lord, kindly, my lord, take, my lord, paragraph 103, which is, my lord, print PDF page 58, my lord. My lord, section 6, my lord, had been challenged. My lord, of, my lord, the act. My lord, kindly come, my lord, to, my lord, paragraph 104. 103 is where the discussion starts. My lord, at page, my lord, 59.
But this was argued by.
No, of course it was.
Is there in the compilation, it was argued by the learned advocate.
And my lord, accepted.
Majumdar's case, my lord.
And accepted. And accepted. My lord, this is what's important, because, my lord, yeah. No, I can do that, my lord. My lord, with the greatest of respect to my learned friend has handed up, my lord, a compilation of cases. My lord, I'll borrow, my lord, the compilation handed up to your lordships and distinguish each one of them. I am only, my lord, starting now, my lord, on the cases. So my learned friend need not, my lord, be worried about me, my lord, not pointing things out. My lord, I would expect, my lord, an uninterrupted run from either side. From your lordships, always, my lord, open to, my lord, interruption. Now, my lord, kindly come to, my lord, 104. A bare perusal thereof would reveal that it is on receipt of information and recording thereof under section 154 relating to any scheduled offence that the officer in charge of police station shall forward a report to the state government. What is to be done on receipt of a report under 1 is then provided by subsection 2. That receipt of information and report to the state government by officer in charge is one step. The second is a receipt of a report under subsection 1 and thereafter forwarding that report as both are thus mandatory. Thereafter, the central government shall determine on the basis of the information made available by state government or received from other sources within 15 days from date of receipt of report, whether offence is scheduled offence and also having regard to gravity or another, whether it's a fit case. Thus, under subsection 3 of section enables and to take a decision on receipt of a report, information contained, etc. Then, my lord, kindly see 106, which is, my lord, the most important, my lord, paragraph, my lord, in this judgment. Because, my lord, this decision-making process must, my lord, has to, my lord, be, my lord, serving the purposes of this act. And, my lord, I shall read, my lord, the statement of objects and reasons and the preamble which have been referred to during the course of this judgment. 106. We are not in agreement with Mr. Jethmalani that section 6 of the NIA Act confers absolutely arbitrarily unbridled and unguided powers. It is a submission that there are no guidelines for exercise of this power. Therefore, this power absolutely so. That is not the position, because it will be necessary for the central government to determine for itself by recording its opinion that the offence which is committed and mentioned in the report from the state government or with regard to which an information received from other sources is scheduled offence or not. Merely because it is a scheduled offence, the central government will not be in a position to direct that it shall be investigated by the agency. It will have to apply its mind to the gravity of the offense and other relevant factors. Gravity of the offense and other relevant factors are not words of inexactitude. They cannot be termed as vague either. The ordinary meaning of the term grave is serious. It is also understood as severe, all-important, significant, momentous, vital, crucial, critical, dangerous, threatening, hazardous, menacing, and a matter of life and death. Therefore, the words in the subsection are indicative of the intent of the lawmakers. They reflect that the offenses being grave and serious may also have an impact. And in relation to the matters, kindly mark this, enumerated in the preamble to the NIA Act. The word gravity is used advisably because the scheduled offense is grave enough for the NIA to step in. It is because it is not only grave and serious, but because it has had such repercussions and ramifications which affect, kindly mark the words, the sovereignty, security, and integrity of India, security of state, friendly relations with foreign states, and offenses under the acts enacted to implement international treaties, agreements, conventions, and resolutions of United Nations, its agencies, and other international organizations, so and so. Thus, as spelled out in the statement of objects and reasons, if the offenses are grave and other relevant factors have to be taken into account, it is then alone the central government can arrive at and record a satisfaction that is a fit case to be in. Thus, there are inbuilt checks and safeguards, and it is not as if uncanalized, unbridled, or totally arbitrary powers have been conferred under so-and-so. So, my lord, whether it's suo moto or on an application, my lord, the decision of the central government, my lord, have to be, my lord, reflective of, my lord, what is provided here. My lord, why was this act there? My lord, the preamble, statement of objects, and my lord, that it, my lord, this decision has to be such, my lord, which, my lord, takes into consideration, my lord, matter stated. Then kindly see, my lord, paragraph, my lord, 108. My lord, PDF page, my lord, 61. Even if a suo moto exercise of the above noted power is permitted, even then the central government is not discharged or relieved from its obligation and duty of recording the requisite opinion and satisfaction. To enable it to exercise the suo moto power as well, the central government must have material before it. That also suo moto power is unfettered and will not be guided is not a proper and correct reading of the statute and its scheme. Even for suo moto power to be exercised, the central government must have before it some definite material and which would enable it to hold that the offense is scheduled offense, and having regard to its gravity and other relevant factors, it is fit to be in. Merely because suo moto power can be exercised without any report from the state government does not mean that the same can be exercised without any material information at all. Further, the information that is made available to the central government and from varied sources will enable and guide the exercise of the suo moto power. Still, the central government is obliged to record an opinion that the scheduled offense has been committed, which is required to be. That opinion will have to be recorded by taking into consideration the gravity of the offense and other relevant factors. Besides that, the central government will have to record that it is fit enough to be investigated by NIA. Therefore, the exercise of suo moto power will also be guided by what has been stated and provided in subsections 3 and 4 of section 6 of NIA. That is the interpretation which will have to be placed on the words if the central government is of the opinion that scheduled offense has been committed, which is required to be in. Once we are of the opinion that even subsections or parts of a section or parts have to be read together and harmoniously, then there's no room for apprehension voiced by Mr. Jetmalani that central government will exercise suo moto power by ignoring and brushing aside the mandate. So, my lord, now kindly have a look. My lord, this, my lord, reference to NIA, my lord, doesn't, my lord, happen, my lord, when there's no mention, my lord, of it in the report, where, my lord, an obligation is cast to the police officer to give to the state, and then, my lord, state forwards it to central government. My lord, even if suo moto, my lord, the satisfaction has to be recorded. It can't be, oh, we've received this, now kindly direct NIA. I'm sorry, with the greatest of respect, my lord, that is not the case. Now kindly have a look at, my lord, the act. I believe a copy, my lord, has been given. My lord, now, my lord, kindly have a look at the, my lord, preamble first. My lord, this is what has to be fulfilled. an act to constitute an investigation agency at the national level to investigate and prosecute offences affecting the sovereignty, security and integrity of India, security of state, friendly relations with foreign states and offences under acts enacted to implement international treaties, agreements, conventions and resolutions of the United Nations, its agencies and other international organizations, and for matters connected therewith or incidental thereto. My lord, there's not one statement, my lord, anywhere that it relates to this. Now, my lord, kindly take statement of objects and reasons. Over the past, India has been the victim of large-scale terrorism sponsored from across the borders. There have been innumerable incidents of terrorist attacks, not only in the military and insurgency affected areas and areas affected by left-wing extremism, but also in the form of terrorist attacks and bomb blasts in various parts of hinterland and major cities. A large number of such incidents are found to have complex interstate and international linkages and possible connection with other activities like the smuggling of arms and drugs, pushing in and circulation of fake Indian currency, infiltration from across borders, etc. My lord, apropos, my lord, what fell from your lordships as, my lord, an incident, my lord, where, my lord, it's a third group which has been pushed in, my lord, which, my lord, has, my lord, these ramifications. My lord, there has to be formation of opinion here. Then, my lord, kindly see, keeping all these, it has long the need for setting up an agency at central level for relating to terrorism and certain other acts which have national ramifications. Several experts and committees, including so-and-so, government after due consent examination proposes to enact, etc. Now, my lord, this is the basis. Now, my lord, I'll deal with, my lord, all the judgments in 2 minutes. My lord, if I may borrow, my lord, your lordship's, my lord, compilation, which was handed up, my lord, by Mr. Bhattacharya.
You can give your copy.
I have already.
Sir,
supplied a soft copy.
No, that's
Sir,
No, this came in my mind in the morning and I prepared it. So,
Let me finish it, please. Give me uninterrupted. Huh?
we're all argued, my lord. It's all fine.
Yes, yes, my lord. I remember everything. My lord. I'm grateful.
Only thing, Lordship, here all the FIRs were started at the instance of the police officers.
Conclusion, my lord. So far as my lord is-
Yes. Now, my lord, with the greatest of respect, my lord, to my learned friend, my lord, he gives me too much of a compliment that I remember every line of every judgment, my lord, where I had appeared. But, my lord, I will, my lord, deal with, my lord, this. Now, my lord, kindly take, my lord, paragraph 5, my lord, of the first judgment. In fact, paragraph 4, my lord, the report, my lord, which was filed, my lord, at pages 1 to 18, your lordships will find, my lord, that, my lord, Explosive Substances Act, my lord, is mentioned.
Yes.
Para 5 also it is mentioned. Para 6 also it is mentioned. Then, my lord, your lordships will find para 9, my lord. I think this is, my lord, so-and-so has not disputed at page 7 that the scheduled offense, but it says that every is not required to be. He has referred to and has submitted that only in 4 circumstances, so-and-so, are offenses affecting sovereignty, so-and-so had placed reliance. This is what my learned friend, my lord, wanted me, my lord, to, my lord, show. Then, my lord, kindly come to, my lord, paragraph 13. My lord, where, my lord, the discussion, my lord, starts, kindly turn over to paragraph 15. My lord, 2 writ petitions, my lord, which are, my lord, scheduled offenses. The undisputed position, defined schedule, the schedule covers the offense, so on, etc. A bear that on receipt of information, so as to be read as mandatory, keeping. My lord, these are, my lord, duties. And, my lord, para 20, subsection page 13, requires central government to determine within specified period of 15 days to firstly whether it's scheduled and secondly considering the gravity. If the central government opines that offense is scheduled offense, then it is required to. Above view is duly supported by so-and-so. In the present case, though admittedly scheduled offense, but the officer has not sent the report, etc. Now, my lord, kindly come to, my lord, the next writ petition. And this is important. Because, my lord, here, Explosives Act was mentioned and not explosive substance. But kindly have a look at para 25, page 14. It is the undisputed position before this court that in this case, the bomb had exploded. So, my lord, the fact had already said, my lord, that the bomb, my lord, had exploded. Now, my lord, on that basis, my lord, under 6(1), direction was given that police should give it to the state, etc. Now, the second judgment, my lord, is at pages 19 to 26. My lord, kindly have a look at, my lord, page 21. My lord, 480, 481, 482, your lordships will find, my lord, had, my lord, Explosive Substances Act. Then, my lord, your lordships will, my lord, kindly come to my lord, the next, my lord, decision, my lord, which, my lord, is at page 27. My lord, kindly take, my lord, last 3 lines. My lord, I had made the submission, my lord, that is, and this is the procedure, my lord, which will. Then, my lord, and your lordships will find, my lord, at page 31, my lord, last paragraph.
Page 30.
My lord, matter was disposed of on the basis of that.
Yes.
Then, my lord, kindly take page 32 to 34, my lord. My lord, there, my lord, independence, my lord, had been, my lord, questioned. So, my lord, central government was asked to take a stand on this. Then, my lord, comes, my lord, page 35, my lord, on Indo Sundar Das. My lord, kindly take 3rd paragraph at page 35. My lord, on that basis, my lord, matter, my lord, disposed of. My lord, page 37 is a, my lord, affidavit directions. And my lord, to which, my lord, after, my lord, the orders, my lord, which have been passed, my lord, page 42. My lord, again, the statement, my lord, is recorded. First paragraph. And my lord, the Bhupati Nagar, my lord, ultimately got disposed of, page 46. Again, my lord, on the statement made. Because initial report didn't have it. There was, my lord, a report which was awaited, my lord, from the forensic laboratory. Moment it came, it found, my lord, that, my lord, the explosive substances, my lord, that was included, my lord, in, my lord, the offense, and, my lord, the matter went. My lord, may I'm grateful, my lord. Now, my lord,
Within 4 to 5 months. Within 4 to 5 months, you've got 8 orders. Does it not reflect something else? I have not seen, in this 14 years, I have not seen so many orders in quick succession. And all concerning some religious function.
yes, my lord, but NIA has also not investigated all of them. My lord, decided to investigate some.
Then, of course, state was fair enough to say, yes,
Yeah.
it involves a schedule offense.
Yes.
And it has been referred. But then does it not tell upon something else?
Absolutely. My lord, it's not something to be proud of as a state,
No,
but my lord,
that's-
only, my
but
lord,
then-
my lord, one thing I must tell your lordship, my lord, this is not the only state, my lord, which, but that is not an excuse.
We are only.
No, my
concerned
lord, that's
about
what I
us.
said. My lord, I'm, my lord, not, my lord, proud about, my lord, with what is happening. And my lord, your lordships will, my lord, find that, my lord, in court, my lord, certain stands which are taken, my lord, your lordships will kindly appreciate that. That's all that I want. My lord, nothing more.
No, no, that will.
Nothing more. My lord, I am willing to take as many brickbats from the court. But my lord, no, my lord, that's the job of the Advocate General. My lord, it's a crown which is supposed to have thorns. My lord, no crown, my lord, is, my lord, without thorns. That's a responsibility taken, and my lord, it will be, my lord, carried out as long as I'm here.
But let us say 30th of August 2022, there is a very detailed judgment. That judgment has had no impact on any other subsequent incidents. It is not, I mean, what do you say? Did it have a desired result? See, always they say, what do you say? Pot of boiled so entire thing is cooked. In a pot.
No, I appreciate, my lord. I appreciate. It must. It has to. My lord, that's, my lord, a fault, my lord, which I, my lord, will accept.
What is it incapacity of the police or failure of intelligence or the inadequacy of the force or some little lack of expertise or more sensitization of the officers are at the lower level? What is required?
Yes. Now, my lord, my view, I might be totally wrong, my lord, the little, my lord, that I have, my lord, it's, my lord, sensitization at the lower level. They feel, my lord, that this is, my lord, what they are supposed to do and go ahead, which is not correct. My lord, they have faced my wrath as well. My lord, whenever I've made, my lord, the concessions, when they've come, I said, what have you done? The report should come, because, my lord, the act, my lord, doesn't result in, my lord, once a report is given, stoppage of investigation. Investigation is also to go on. Your lordships will find that in 6.6. Till, my lord, NIA decides. Investigation is not arrested.
But these orders have had no effect at all. Had no effect. Because once bitten, twice shy. If suppose you have had history, the recent was in respect of Lakshmi Puja. So what should have been the preparedness?
My lord, that is, my lord, for maintenance of law and order. My lord, my lord, we are on 4 issues now. My lord,
we are on multiple
no,
issues.
Yes. My lord, I was only addressing your lordships now, my lord, on, my lord, NIA.
NIA,
yes.
No,
My lord, that is number 1. My lord, what your lordships have mentioned, lordships are absolutely right. My lord, it's a larger issue. My lord, and my lord, it's a very important issue, because, my lord, we should be proud of, my lord, having, my lord, or being, my lord, residents of a state which, my lord, is peaceful. But, my lord, I find.
See, suppose this involves some blast, some which took place, etc., and firearms were being manufactured, intended to be sold, intended to be shipped elsewhere, etc. That may be. All these concern the public. That's the very disturbing factor. All of the incidents which have led to either the state themselves handing over the papers to the NIA, all concerns the general public. And bordering religious ceremonies, functions and festivals. It is not as if somebody was making bombs there. One went off. Thereafter, the investigation took place and they found a full-fledged factory. What a strange incident. This nitrous oxide, which is imported, goes missing from the wharf. The sweepings, there's a huge investigation being done on that. That is why now, unless he is a manufacturer of
with a license,
I mean, he cannot import. In fact, that was challenged. I upheld the provision. Now the matter is in Supreme Court. So the report says the sweepings which fall off the vessel in the wharf before it is being transported, huge quantity of the sweepings go missing.
Not only that, my lord, even scrap.
Yes.
My lord, scrap which was being imported, my lord, half of them, my lord, would explode.
So that's it. We'll consider.
My lord, that's what I wanted to point out on, my lord, NIA, because that's
no.
But my lord,
exception is required. We will
My
consider.
lord,
my lord,
only violence is going on. Sometimes postpone violence, sometimes Saraswati Puja violence, sometimes Durga Puja violence. It is going on.
Durga Puja, I think there was no violence.
No,
Fortunately, fortunately.
Violence is going on.
Malda,
Malda.
That is submitting that Hanuman Jayanti or Ram Navami, they were not that popular in Bengal, it was Durga Puja. But we also have judgments of the Honorable High Court where immersion of the Durga Puja was stopped and the court had to intervene. That is the prime festival of the Bengalis here. But the court had to intervene also.
That Malda violence was.
Lord, I just want to, Lord, I just want to point out only one thing. In my writ petition, Lord, I have made two prayers. One for, Lord, registration of FIR and transfer of investigation to CBI and by investigation by NIA. Lord, I have shown your Lordship.
So
Lord.
is it either or alternative prayer or both?
No, Lord, both the prayers have been made, Lord, that, but
How
we
it
have,
can be both
but we have not argued on the NIA aspect, Lord, before your Lordships. One more aspect, Lord, we have shown your Lordships the perfectory investigations are going on. Sitting in the offices, reports are being prepared and all FIRs are not filed by the police. So, Lord, purposefully, they have not included those sections, Lord, of the Explosive Substance Act.
Yes, cleverly.
This has been done purposefully.
Cleverly, they have not added
May I-
substance act.
This has been done, they are shielding it. State is shielding fact from the court.
My lord,
This is done purposefully.
My lord, that's, my lord, a fairly serious allegation.
Yes, I have made that in the writ petition.
My lord, may I indicate?
I made.
My lord, the seizure report, my lord, was read out. It takes 20 minutes, 15 minutes. My lord, the police officer is willing to file an affidavit that it's within 100 to 150 meters, all the places.
Very well, let us see. Timing, Kyle.
Yes. So, my lord, to just, my lord, make, my lord, allegations off the cuff, my lord, the question, my lord, does not arise at all.
Lordship, the second petition, I am for the petitioner, Lordship. May I please?
Not
You already
What I want.
use the microphone.
I want one report
may
to
I
be placed in respect of my petition where my specific allegation is the administration was made to be silent over the entire issue for a certain time. The administration was awaiting to see this kind of incident happens because it was prompted by very responsible person holding a constitutional office of the state, none other than the Chief Minister of the state. I have annexed one statement which was published in India Today. Page 25, I have annexed her statement. The statement was made during a political program where she stated, I want to request that those who are taking the processions.
Wait,
Yes,
let us take page 25.
page 25 and relevant portion is in 26.
Wrong file.
May I read?
Everything separate. Then put everything. Lord,
26 page.
Yes.
I want to request that those who are taking out processions for Ram Navami today, please do, but do it peacefully. Kindly avoid the Muslim areas as Ramzan is going on. Celebrate peacefully and don't try to create violence. Don't get provoked. Some BJP leaders are saying they will come in with swords and knives during the processions, but don't forget, a criminal offense is a criminal offense and the courts will not spare you. The question is, this entire statement has two twists. One, Lordship, there is a request of peace, maintaining peace, but at the same time, the Honorable Chief Ministers had tried to divide the area which on the basis of the religious identity, which is anathema to any of the secular state like India. Can a place be divided on the basis of the religion, Muslim area and Hindu area? This is not the situation she has attempted. And this was the statement made by her on the last day. And this was promptly, and she holds the position of the police ministry also. Now, this kind of statement provoked these people to instigate, as I have pointed out on the last occasion. There were certain things which shows the entire incident was the result of the pre-planned mechanism. Stones were pelted from the rooftop, though it was denied, it was stated on media that the procession was coming to a different route, which was not permitted by them. Now, so these things are enough to show that there were a plan where police had participated. So, Lordship, I was trying to beseech before your Lordship to pass a judgment, to restrain the political leaders to make such irresponsible comments, and also to direct the police to give a report on the form of affidavit to explain what has prompted them not to take any action for a certain period of time. Because it's the lapse on their part to take the immediate action. It is now evident that police did not take immediate action to stop the violence in case of Howrah. So therefore, one direction should be there in terms of the prayer A made by me in my in my petition. Now, Lordship, B and C, prayer C is for the NIA investigation. In respect of that, Lordship, I have only one thing to say. NIA is an investigating agency, national investigating agency. Police is the state investigating agency. CBI is also an investigating agency. Now, it appears to us that since there are the political division between the party in power at center and the party in power in the state, that means every time the one investigating agency will abuse another investigating agency. Now, this is the problem which has cropped up. Lordship has gone through those orders which were passed in last 4 or 5 months. Lordship will find there is one order might be passed in the case of Sarabat Ali versus state of West Bengal, which is annexed. I have overlooked it from London Advocate General's brief. Lordship, that order was not implemented. The court had to direct the NIA to consider it. So now the non-action on the part of the investigating agency, there may be sometime there may be the non-action, inaction on the part of the investigating agency. Even the NIA may say that we are not going to opine our opinion in this particular matter. But the question is, here we are on a different issue, that the beginning, the threshold, at the beginning, there is an attempt by the police officers that we will not include those sections under Explosive Substance Act to investigate that, so that it will fall under the schedule offense. So this is a question whether in case of general hurling the bomb itself will draw the attention of the NIA for its investigation or not, has to be looked into by this court. And third thing, Lordship, I will be beseeching your Lordship to pass an order in direction in terms of prayer F in my writ petition, directing the Police Commissioner Howrah to file a report in the form of an affidavit furnishing the preventive measures taken by the police on the date of Ram Navami, that is 30/3/2023, in context of the public statement made by the Chief Minister. Because Chief Minister's statement, which was an alarm to all the administrative officers, including the police in the state, that statement itself, she said that there was information that some goons of one political party are trying to create these mischiefs in that some areas. Now, what was the steps, measures taken by them? Howrah Police Commissioner should furnish an affidavit to that effect, Lordship. I conclude my submission. And the similar incidents was also taken in the same spot last.
You have heard so and so, orders reserved.
Item number 10. Kindly tag with item number 10, my lord.
And Lordship, Honorable Chief Minister has made a party in my petition.
Record.
So
12th respondent. 12th respondent. 12th respondent.
12th respondent.
Correct.
So I have. She has been served.
We have some.
But affidavit of service may be kept in the record, my lord.
Affidavit of service kept in.
Affidavit of service kept on record.
What was argued by the learned Advocate General, paragraph 9 and paragraph 23 of the first judgment in the
Yes, we saw.
Lord, may I just?
Yes, sir.
Lord, in your lordship's last judgment in this case, my lords have been pleased to observe that prevention is better than cure. Now, this matter has two aspects. One about the incident which has occurred, and about the cure and prevention for the future. Now, my lord, only last question submission about question of law has been advanced by the Advocate General is that the act and its interpretation. The Bombay High Court judgment, even if it has a persuasive value, has now been merged with the our judgment. This has no persuasive value now. our judgment will prevail. The lordships will kindly follow that. Now, finally, question is, once there is an allegation of a blast and it attracts whether the Explosive Substance Act and the Prevention of Illegalities and the other act, if my lords find that these two acts are attracted on the allegation and there is no specific report of denial, then your lordship can direct us to file a report as to the incidents. And then on perusal of the report, your lordship will find out whether further investigation shall be carried or not.
Yes. Yes, I do.
Serial number 3.
Yes.
Lord, I beg to appear on behalf of the petitioner, my lord. I'm praying for not today, my lord.
Why?
My lord, my senior is in
Why
some
you
other
moved
court,
the
my
matter?
lord. My lord.
What is the matter you tell?
My lord, I don't have the brief in hand, my lord. The brief is with my
Mandamus
senior.
directing respondent BDO to transmit.
My lord, kindly accommodate today, my lord.
What is the special investigation team?
Lord, he is challenging the notice inviting tender and the works done there under.
But I think yesterday somebody mentioned saying that this tender has been given to.
My lord, only I'm praying
No.
for 1 day accommodation, my lord.
No, it will go in, then you will mention for upgradation.
My lord,
How we can upgrade?
I shall mention, my lord.
And my lord, nothing was done by them before moving this court. Vague allegations devoid of particulars. Kindly see the representation even. No particulars.
Where is the representation?
Well, that page. Give me a second, my lord.
No, this is very vague.
My lord.
You say that various anomalies in implementing the project.
Absolutely vague.
You make a very correct
representation.
This by way of, please take down, by way of this public interest writ petition, the petitioner seeks action on his representation given to the district magistrate dated 20th of March 2023. This concerns an allegation of improper works under Rautat Roman II Panchayat Samiti. We have gone through the representation which has been appended to the stay petition, and we find that the petitioner has stated that the work of installation of the submersible pump with tank has not been carried out properly, and there is various anomaly in the implementation of the said project. And the same is grossly illegal and amounts to cheating the public exchequer. We find the representation, strike that out. We find that the allegations in the representation are absolutely vague. And based on such representation, we cannot issue any writ of mandamus as sought for by the writ petitioner. Therefore, we dispose of the writ petition by giving liberty to the writ petitioner to make a comprehensive representation to the district magistrate, giving specific information as to why, in his opinion, that the said work was improperly carried out. And as regards the alleged illegality committed by the authorities, if such representation is submitted, the district magistrate shall consider the same and pass a speaking order within a period of 2 weeks from the date of receipt of the representation. Writ petition, not stay petition.
My lord, pass a reasoned order upon hearing the party, my lord.
Next.
Grateful, lordship.
Serial number 4. Lord, I appear for the state respondent. This is a service matter. Transfer order is sought to be, my lord, challenged in a
PIL.
PIL. This objection I will be taking after the petitioner.
No, if the headmaster of the school is transferred, these children will be affected.
Yes, well, and the
question is in violation of all rules, norms, statute, everything is there.
No, if you go into that, then it will become a private interest litigation.
No, because of the.
If you want a headmaster, we will get you an headmaster.
Headmaster is there. Headmaster, what has happened, your lordships, my lord, I am telling you, lordships. My lord, I cannot file an individual writ, my lord, because I have no, without filing a appeal, my lord, I have no other alternative way.
Why?
Because of the fact, my lord, I am ex-student of the schools. And after the appointment, when my lord, it was started, the school is not running in well. And I came to know about the, my lord, the transfer policy or transfer matter, in which way he procured that. Scam is going on throughout the Bengal, your lordship knows that. My lord, within 1 year, teachers, the private respondents, within 1 year, he has been transferred thrice. First, my lord, he was the assistant teacher. He became the headmaster. He joined the schools. Within 1 year, my lord, by virtue of the special ground transfer, under the rule which is not permissible before 5 years, he has been accommodated in the schools and he is spoiling the present schools. This is the issue. Anyhow, my lord, the affidavit of service, I should say, my lord, it had been sent. The track report is not there. Who is the?
No. Who's the 9th respondent?
9th respondent is the headmaster. Right?
Now you want him to be there, or you don't want him to?
No, because of the fact in violation of the all rules, statute, regulations, everything, he managed the transfer order. How can it be? Let him come and let him explain. And when the state may be directed to file a report, how can you within 1 year?
How is a student interested in this violation of
because of the fact after appointment of this gentleman, Malal, the school is going to be spoiled. Whatever it may be. If the corrupt practice, his birth is on the basis of the corrupt practice, then it is not expected the students will be benefited.
Now, who was the person who was transferred and he's been accommodated?
Malal, this is the respondent number 9.
You don't want respondent 9.
Question of mine wanting or not, it doesn't depend. Questions a valid, suitable, qualified persons to be appointed. I have no grievance against.
All right. How does a student know that he is not qualified?
No, not qualified. Qualification means a person who is managed to get his transfer.
How does a student know?
Because he's the student. I have filed and RTI applications. Everything has been supplied. On the basis of the RTI application, everything has been supplied.
And then did you give a representation?
Yes.
To the concerned authority?
Yes. This is the page 43. The secretary school.
And what is the response?
No response.
And has the 9th respondent joined?
9th respondent joined there. I subbed the copy, but the track report is.
He is working there for 1 year. Students are not coming. Guardians are not coming. Ex-student filing appeal.
But after, should you not say how the school deteriorated? If he is an ex-student or he is a member of the Parent Teachers Association or something like that, he will know. The Madhyamik results, 100 students failed. In the +2 examination or the board examination, 50 students failed. That should be the concern of an ex-student. I feel we sincerely feel.
8 teachers, I tell you, lordships, 8 teachers who is not eligible to be transferred.
That you cannot go into, you cannot as a public interest litigant, if you step into that.
No, because I tell you, lordships, the education scam throughout the Bengal, it is going on. Investigation has been started regarding transfer matter also.
This is not a public platform.
No,
this is a
this is the case where, my lord, I have got the information on the basis of the RTI applications, and it appears from the record less than 1 year he has been transferred. And under the rules, he is not be permitted to get the transfer. First, he joined the A schools, he joined the B school as headmaster, he joined within 1 year C school as a headmaster. How political influence is, how we get and how we manage to get the transfer order. Let him explain, let him submit a report. The state should submit a report.
There's something more to the litigation. What is the writ petitioner doing at present?
At present, my lord, I have said that I am the student and I am the social worker, a student of the said schools, and my contribution to his life.
And who approves the order of transfer?
Yes, madam.
The transfer, is it a state level list? And who approves this transfer? The commissioner or secretary?
The school service commissions. The transfer authority. School service, the CBI is going.
No. This is by board.
No. Board issued the appointment letter. But the transfer is.
How he is?
I'm for the private school, but I've been.
Ninth response.
Copy of this, sir.
Oh, no, copy the.
I have not received that.
Oh, that is another question. I have sent it. I can immediately here and now in course of the day.
His allegation is,
Yes.
you are a very powerful person.
That is not correct, but I make an application in 2020 when the pandemic situation is going on. Well, after considering that application, well, I have a brilliant student that is I am posted as headmaster due to long distance. Well, I went from
But his allegation is.
within 5 years.
Yeah, yes.
But that the present rule of 2018, that is not that there is no such.
But if there is discrimination, like
But-
people are standing in the
But-
queue with application.
Well, I put a question myself.
We have already asked him.
Well, he has not passed even the school final examination. He's such a student.
Oh, he's a dropout.
Yes. Free speech out saying that he's interested in education. Free speech.
He will not respond to the illegality which has been
I
made.
shall file the evidence stating all these things to my lord.
Very well, let him do that.
Let them submit a copy.
No, still your locus standi on this issue.
Yes, that I shall, that
Lord, I am fully prepared with regard to the standing. First of all, he is claiming that he is a
All right.
free.
I'm
Let
sorry,
papers
copy
be
here.
served. Let papers be served on the learned advocate appearing for the ninth respondent. Put up the matter after 2 weeks. Papers within 2 weeks. Let affidavits be filed by the respondents within 2 weeks from the date of receipt of the papers. Reply if any within a period of
Kindly give me 3 weeks time because you are
weeks. Within reply if any within a week thereafter. List the matter in the monthly list of May.
My lord, only
I'm
one,
serving the copy here and.
my lord, only one other thing, my lord. Since directions have been given, my lord, question of maintainability be kept open.
We make it clear that the question of maintainability of the writ petition, question of the locus standi of the writ petitioner.
As also maintainability.
Also the maintainability of the writ petition as contended by the learned standing council for the state will be considered as first among the several issues.
Good.
Which will be
Extremely good.
taken up for consideration.
Good.
Serial number 5. My lord, I beg to appear on behalf of the petitioner. I am led by Mr. Sabyasachi Chatterjee in this matter.
My lord, I am appearing on behalf of respondent number 7, 8 and 9.
My lord, affidavit of service may be taken on record.
on behalf of the state respondents.
My lord, in this matter, some villagers of Kulpi village in South 24 Parganas district. Now, my lord, what they are doing, they are making different job cards under the Manrega scheme. And now, my lord, they are dividing a single family into 5 or more parts to obtain more benefits. My lord, this is the gist of the matter. And we have made a representation to the concerned authorities as well, my
There
lord.
is the representation.
My lord.
Representation should not be through a
My lord,
lawyer's notice.
my lord, in page
advocates,
number
advocates, the representation.
32.
Petitioner is an advocate.
No, my lord.
No.
Through advocate.
And vital thing
No.
is that, my lord, the Pradhan was not made party.
Pardon?
Pradhan of the Gram Panchayat was not made party. All the allegations are against.
You give a representative.
Well,
Who is the authority, Mr. Siddhi, who will consider the
The
representative?
BDO, my lord.
Block development
Block
officer.
development officer, my lord.
Is he a party here?
My lord,
Block development. Development officer,
my lord is a party.
Fourth respondent.
My lord, fourth.
This writ petition has been filed as a public interest litigation, seeking for direction upon the respondents to go into the allegations of misusing the
Number 5.
what is it called? MGNREGA. NREGA scheme. We find that the representation has not been given by the petitioner, but by a lawyer's notice has been sent. And the averments in the lawyer's notice does not specifically state as to which of the several residents of Ramakrishnapur GP have colluded with the officials by resorting to defrauding the government in implementation of Pradhan Mantri Awas Yojana. The petitioner, if he has got material, has to specifically state in his representation as to who are the illegal beneficiaries. Therefore, we are of the view that a comprehensive representation has to be given by the writ petitioner and not by way of a lawyer's notice which does not contain details. Therefore, we dispose of this writ petition being giving liberty to the writ petitioner to submit a representation to the fourth respondent enclosing all records in support of their claim. On receipt of the representation, the fourth respondent shall afford an opportunity of hearing to the writ petitioner and all concerned, and thereafter proceed to consider the representation and pass a speaking order on merits and in accordance with the law. The above direction shall be complied with by the fourth respondent within a period of 4 weeks from the date of receipt of the representation. Full stop. If in the opinion, any of the beneficiaries have availed, wrongfully availed the benefit of the central government scheme, then notices should be issued to such of those beneficiaries as well, and they should be heard in the matter.
My lord, on behalf of respondent number 7 and 9, my lord, I am denying all the allegations made in.
They may pass an order.
Sir, the learned advocate appearing for the respondent 7 to
7, 8 and 9.
7 to 9 submitted that the private respondents have they are denying all the allegations which have been made by the writ petitioner in this writ petition. The said submission is placed on record.
Grateful, Lordship.
Serial number 6.
Yes.
This is again the petitioner has come before your lordship against the filling up the water body.
Water body.
My lord, complaint has been made with the local. So back to my lord, page 15,
They have filled it up already, or
going on. At
why are
random.
you, sir, why are you filling up the water body?
Me,
Me means
I am to protect.
your client. Who's filling up the water body?
My lord, the respondent number, my lord, I have made my lord 8,
My lord.
9 and 10. Our local persons, they are land mafias with the connivance of the local municipality.
And who is the authority who has to take action?
My lord,
My lord, the
municipal
municipality can take action based.
municipal area
Municipal
under the
area,
law,
huh?
under the
Your
West
lordship,
Bengal
yes.
Inland Fisheries Act 17 capital
Yes,
A. The executive office, the
Ninth, sixth
6,
respondent.
my lord, your lordship can direct the 6, 2 and 6, your lordship. Your lordship can direct the district magistrate to ask for a report.
no.
Yes.
দাঁড়া,
kindly allow
এই
me to
দাঁড়া,
find that.
দেখে নে,
No,
দেখে
no.
নে।
As per the
I know.
Inland
No.
Fisheries Act, it's the municipality which has to take action.
6, my lord.
Six. This
Kindly-
Municipal commissioner.
Yes.
by this writ petitioner, the petitioner seeks for appropriate direction to the sixth respondent municipality to take action on his representation dated 27th February 2022, 27th July. No. To representation received by the municipality on 31st January. 31st January you had given the
Yes,
representation. 2022. The allegation in the representation is that the private respondents, namely 8 to 10, are filling up a water body. Though the representation is stated to have been given in January 2022, it is not clear as to what is the present status quo. Therefore, it has become imperative for the writ petitioner to give us fresh representation along with a copy of this order. In the light of the above, the writ petition stands disposed of by directing the petitioner to give a fresh representation along with a copy of this order to the sixth respondent municipality, who on receiving the representation shall issue notices to the respondents 8 to 10, direct an inspection of the area to be conducted, and also after affording an opportunity of personal hearing to the petitioner, take action on the representation and pass a recent order on merits and accordance with law within a period of 2 weeks from the date of receipt of the representation.
My lord, 2 weeks may not be sufficient.
Private respondent. 3 weeks. After hearing the writ petitioner as well as the respondents, 8 to 10. Next.
Serial number 7.
Yes.
Your Lordship, I am behalf of the petitioner, but
Ah,
my
what-
affidavit service is not affirmed still, so could it?
You just adjust the microphone. You adjust the microphone for him.
Your Lordship, I am for the petitioner. My affidavit service was not still affirmed, so could it be possible to adjourn for the day and take it tomorrow?
No, what is the matter? You tell us.
The matter is that for admission in BA LLB course of Bardhaman University, process of the admission in BA LLB course.
Well, it has been alleged, my lord, that the admission is happening without the entrance examination, my lord. So he seeks a mandamus, my lord, that the entrance exam must be held.
The entrance exam must be held, and the money which was taken, it's in which ground the 250 rupees was taken without the entrance exam. I allege that.
No, you are appearing for the university.
No, no, my lord, I'm appearing for the respondent number 5, my lord.
Who's the
For the-
respondent?
Bar Council of India, my lord. The respondent number 3, the university is the necessary party here, my lord.
That is true. University, he says it has not been affirmed.
My lord.
But what is the selection process? Which
My lord, I have taken instructions from the Bar Council of India, my lord. It is required, my lord. Only during the COVID period relaxation was given, my lord, but now otherwise even they penalize, my lord, if this is not followed.
Are they selecting with the CLAT score, or are they having a separate?
Separate, my lord, what they are doing
Separate
is
exam. Separate exam is every year is happening. The Bardhaman University has taken last exam on 2019. The COVID situation is there, so there will be.
COVID situation is over.
Is over, my lord. Prima facie, there's some merit in his case, my lord.
All right. Why do you want an adjournment?
The affidavit service is still not affirmed, so
Which
would it be
affidavit
possible?
of service?
Affidavit of service, my lord.
Affidavit of service.
Who was the standing counsel for the University of?
I am.
No.
No, I am the petitioner.
Mr. Nolan Vihani appears for the Bardhaman University, my lord.
Then.
The 3-year course or a 5-year course?
3-year course, my lord. He has
3-year
filed
course.
3-year course.
Similar.
That the results of the higher secondary exam.
Absolutely, my lord. Your lordship. A
That's
similar
the
thing
chance.
had happened during the COVID. My lord. I am the retainer of Calcutta University. But during the COVID, my lord, we could not afford to take the entrance examinations. So, my lord,
What happens in Calcutta University?
well, last year also, my lord, we did not hold a entrance examination. My lord, there were litigations to that effect. My lord, we have assisted the court due to the COVID scenario. My lord, court had
Now you can't.
now we cannot. My lord. Now this year on.
Calcutta University in 2020, it was also held.
2020.
So during the COVID period.
It was held in 2020. After 2021, it was not held. My lord. But my lord will kindly hear out Mr. Vihani. May I inform him? My lord will be pleased to fix the matter at 2 p.m.
And,
or
without entrance exam on basis of marks.
on the basis of the marks of the higher secondary, best of 4.
Now, Your Lordship, the admission process is conducted by the university, Your Lordship, by the on the basis of the marks obtained in the HS and the Madhyamik examination, Your Lordship.
That should not.
Tomorrow?
But I'll inform Mr. Vihani.
You do one thing, you serve papers on Mr. So-and-so.
Indeed, Your Lordship.
The learned advocate for the petitioner is directed to serve papers on the standing counsel for the respondent university. Let the matter appear in the daily list tomorrow.
Grateful. I'll also inform my lord.
Please.
Serial number 8.
Oblige your lordship.
Lord, I appear for the state respondent. Any. Lord, this was a crematory, my lord. Cremation was going on for more than 100 years. 130 years, 36 years by the bank of the Ganges. Now under the Namami Ganga project, Government of India has asked my lord to construct an electric crematorium at the same place. My lord, that is being objected to. Kindly seize. I've got the one copy is with me. Kindly excuse Justice Bhattacharya will, my lord, kindly see. Kindly excuse me, my lord, flag portion is the
None appears for the petitioner. We have heard so and so learned advocate appearing for the respondent. State. The petitioner opposes the construction of a crematorium with electric furnace in an existing conventional crematorium. The written from the written instructions given by the officer in charge, Jalangi PS Murshidabad, dated 9/4/2023, addressed to the learned counsel for the state.
existence was for last 136 years. Last
It
but
is,
one.
it is seen that the crematorium called Kaliganj Samsa on the banks of the river Silamari in village Kaliganj has been in existence existence approximately for 136 years.
তো রেসপন্ড করো না ভাই, তোমাদেরকে হোয়াটসঅ্যাপে দিলেও রেসপন্ড করো না, ফোন চালিয়ে যাই বাড়িতে তো ফোন করতে পারো 12টা।
It appears that a request was made to the block development officer to set up an electric crematorium, and considering that it will be environmentally friendly, steps have been taken for construction.
Dated 3rd November 2022. Flag portion.
The officer in charge of Jalangi police station would state that if members of a particular community are very much worried and concerned that the influx of the dead bodies to the crematorium will be very huge in number, as there is no electric crematorium situated within a radius of 45 kilometers. And moreover, the conventional crematorium being in a congested area would cause a lot of inconvenience. The petitioner has submitted a representation has been submitted.
Well, if your lordship kindly say something about the administrative approval of the government of India flag portion. Kindly seize, my lord.
No, administrative approval they will grant. Location.
Location is Kaliganj.
Correct, sir. They don't approve the location. The state has to approve the location.
No. Construction of electrical crematorium at Kaliganj.
This should not lead to another 144.
Very well.
The officer reports that. So you consider the reference. In fact, electric crematorium is not environmentally safe.
Is not safe.
Now electric crematoriums are being replaced by gasifiers.
Yes.
Electric crematorium creates lot of dust. The dust is the half burnt flesh and bones. And nobody can reside within a
representation is at page.
They submitted a representation on 20th February 2023 to the block development officer. And it appears that around 50 persons have signed more. It appears that several persons have signed the representation.
But video cannot do it.
In the light of the concern expressed,
kindly direct the
DM.
Yes, that is what I was saying.
In the concern and considering the concern expressed by in the writ petition and in the representation, we direct the second respondent, namely the district magistrate Murshidabad, to consider the representation dated 20th of February 2023, which has been received by the BDO Jalangi, who is directed to place the representation along with all the connected files for the consideration of the district magistrate, the second respondent. The second respondent shall direct an inspection to be done of the area, and if necessary, invite the views of the public, and thereafter and also take note of the aspects regarding whether establishing an electric crematorium in the area will cause any pollution concerns, for which the district environmental engineer can be consulted, and thereafter a recent NED decision be taken on merits and in accordance with law.
Pollution control board.
This direction shall be complied with within a period of.
Instead of district engineer, maybe pollution control board.
Pollution control board. Every district has got a person called district environmental engineer, DEE. Here you don't have.
To my knowledge, I have not seen any.
Yes, DIAC and DR. DIAC হচ্ছে recommending authority.
There is a joint chief environmental engineer who may be district wise or 3 or 4 districts put together. Then the district environmental engineer, no, I have said, no, within bracket, or any other officer of the West Bengal Pollution Control Board in charge of the area. Okay.
আমাদের এখানে হচ্ছে DIAC আর DR.
Serial number 9.
I beg to appear. I am appearing on behalf of the private respondent, my lord. I am led by Mr. Aniruddha Chatterjee in this matter, my lord.
The petitioner before your lordship is, my lord, the aggrieved only because of the fact, my lord, in a local area, my lord, there is a pond, my lord, which is being filled up by the, my lord, private respondents for, my lord, promotion and construction purposes. My lord, we have already, my lord, made representation before the concerned authorities, page 39 onwards.
Photograph shows already construction has started.
Yes, my lord, may I just indicate, my lord, few things. Page 34, lordship, kindly consider for a moment. This was the earlier character of the, my lord, land. Lord, it is clearly visible, Lord, there was a pond. Page 34. And lordship, kindly see, my lord, the current photographs, as your lordships rightly pointed out, my lord, page 77, construction already done. Now, lordship, kindly consider, my lord, one thing, page 37. Page 37, my lord, is the certificate issued, my lord, by the Fishery Extension Department, which says, my lord, may I just read? This is to certify that the land of Mouja so-and-so, plot number 1080, my lord, this is the concerned plot, is recorded as Shali. Physically, it is found that though the total area is recorded as Shali, but there is a pond-like situation within bracket area, within the area at about 31 decimal, where depth is about 7 to 8 feet. It may be treated as pond and physiculture may be done here. Now, lordship may kindly.
That can't be an opinion.
No.
It can be because of water logging also. In the revenue records, has it been classified as a water body?
No, it is not classified as water body, but my lord, may I just indicate one thing?
We can at
Lordship,
best say is direct them to consider the representation.
May I
Lord, lordship may kindly consider one thing. My lord, this is the, my lord,
As
my lord, may I just indicate one thing?
This is a Sali land, my lord. Purchased this through registered deed of conveyance, my lord. We have applied for conversion to Bastu, my lord. The necessary concerned authority has changed the nature and character of the land, my lord. We have applied for sanction plan, my lord. That is with us, my lord. And thereafter,
from agriculture to non-agriculture use, it has been converted.
My lord, the Sali land that has been converted into Bastu land.
That's it. That is what I am saying.
My lord,
Agriculture to non-agriculture.
my lord, may I just indicate one thing, lordship? Lordship, kindly have a look.
Conversion certificate.
My lord, yes, I have mine.
My lord, lordship, kindly consider, my lord, the West Bengal Inland Fisheries Act. My lord, the provision is section 17A. Lordship, kindly consider and have a look. My lord, if lordship kindly see 17A subsection 1. No person shall, my lord, has your lordship got, my lord? Page 848.
No person shall put any water area including embankment measuring 5 cutters or more, which is capable of being used as fishery, or any naturally or artificially depressed land holding measuring 5 cutters or more, which retains water for a minimum period of 6 months in a year. My lord, here the concerned land, my lord, retains water, my lord, for a period, more than 6 months in a year. Lordship, kindly see in that case,
No,
such use.
are you aware of this conversion which has taken place?
No, my lord. I am not aware, my lord, there is no. My lord, in case that conversion certificate is there, my lord, then section, my lord, page 37 should not have been issued.
Must be under section 4C.
The second
After
page.
that,
There's the prohibition for conversion of any water body.
it's not a water body recorded.
Initially
Also not. This is
at no point of time.
No, my lord. The entire plot of land, my lord.
And this is
comprises
second round. This is second round.
7 acres of,
First read
my lord,
petition
But
was
unless you challenge this conversion has taken place in 2019. Consequent of the conversion, they applied for planning permission. Approval has been granted, construction has commenced.
My
At
lord.
this stage, unless you say that the conversion itself is bad, consequently, all other actions are illegal, we can't grant any.
yes.
My lord, they could have, my lord.
And even if your representation is directed to be considered, the
It's-
authority
it's of
will
no
say
use.
already conversion took place.
My lord,
So if
only
you want,
one
you
thing, my lord,
challenge this.
my lord, I do not know, my lord, the veracity of this document, because it is coming from, my lord, the bar, my lord. Unless it is
No,
affirmed.
that you examine, sir. We'll give you liberty, withdraw this writ petition with liberty to challenge the convention order, conversion order.
This is second round. First read petition was also with.
We
So
saw
that
that,
was
we saw
withdrawn on a different aspect altogether. my
Have
lord.
you consulted, Mr. Chakraborty, have you consulted the earlier record of rights?
Lord, earlier record of
But
rights,
plot.
Lord, I have not consulted, my lord, to
So-
be very candid. My lord,
So on
Lordship
that
kindly
ground, we'll dismiss the
what is-
PA.
But the Lordship kindly consider section 17 for a moment, whether, my lord, in view of section 17,
There is a water body. What
yes.
is the basis of your petition that it was a water
My
body?
lord, since time immemorial, there
What
is
is
an
the
water body.
document you have annexed to show prima facie?
Page 28 onwards.
Lord,
kindly
Lordship
see.
kindly see page
You cannot
37.
rely upon the photographs to
Lord, page 37, I have annexed.
decide what was the character of the land.
Page
Show us any document which forms the basis of your petition that it was a water body.
All
if
this,
the-
all this research should have been done prior to filing the report.
Lord, I tell your Lordship, my lord,
Simply
why?
you drop a postcard somewhere. and
Lord,
then
I
file
tell
it.
your Lordship, why? My lord, page 37 is the certificate, my lord, given by the Fisheries
No,
Department
no,
itself.
that's not a certificate. It's neither here nor there. Who's that fellow to certify that? It may be treated as a pond.
My lord, it is, my
Then,
lord, given by the
at
concerned
the
block.
rainy season, the lot of roads are also waterlogged. For 3 months, it's waterlogged.
And it would
My lord,
be.
if it is, my
Newtown
lord,
area.
this area, Lordship kindly consider the photographs. My lord, it photograph
After some
itself
argument,
speaks, my lord, it is.
after some arguments, you give a copy of that conversion order to. After some arguments, the learned advocate appearing for the petitioner has sought permission to withdraw this writ petition with liberty to challenge the order of conversion granted by the Block Land and Land Reforms Officer, Hooghly, dated 30/9/2019. The learned advocate for the private respondent is directed to hand over a copy of the said order to the learned advocate for the writ petition. Next.
My lord, Lordship kindly consider one thing, my lord, although your Lordship has passed. My
Now,
lord, they have
fortunate for
converted,
you,
my lord, they have converted that land, my lord, they are claiming to be a bastu. My lord, the current record of right showing it shali. My lord, I have annexed to my writ petition.
you challenge it in that with the,
Lordship.
May I have an urgent Xerox certified copy?
he's withdrawn it. Next.
Grateful, Lordship.
Serial number 10. 10 already. Serial number 11 to 15.
I make to appear, my lord, on behalf of the intervener. My lord, this is a case relating to overcrowding in different jail. My lord, jail death compensation, dearth of staff in different jail. Lordship was kind enough, my lord, to allow us to submit our report on, my lord, 21st February 2023. We have filed our report.
In fact, there is another division bench which was dealing with this matter. I think headed by Justice Joymala Bakshi, where
No, my
they
lord.
issued directions.
No, my lord. This is a matter which initiated in the year 2017 by the Honorable Supreme Court. My lord, the condition of jail in different parts of India in suo motu and thereafter directed to different high court to initiate same proceedings. At that point of time, this was initiated and this Honorable Court was kind enough to allow us to work as a intervener. My lord, since then, my lord, the matter is going on. Lordship was kind enough to issue certain direction, number of direction. One of the important direction is this Honorable Court was kind enough to allow, my lord, to free 37, my lord, terminally ill people who are incarcerated in different jail. And thereafter, my lord, compensation payment order was made, my lord, for 41 jail detainee. And out of which, my lord, 28 was paid, though insufficient amount, 2 lakhs, 3 lakhs and all this. Remaining not paid. And subsequent stages, my lord, there are number of years have been elapsed, my lord. My lord, so far
the last order was on 21st of February 2020.
yes, my lord. At that point of time, lordship allowed us to submit our report, my lord. That report I intend to place before this Honorable Court, subject to the leave of this Honorable Court.
You have submitted.
Lordship. My lordship, kindly see, my lord, the report.
But what is the response of?
Yes, my lord, I have to, my lord, I have an affidavit, my lord, which has been filed in response, prepared in response. I'm not happy with it. My lord,
We will give you some time
Yes,
because
my-
he's assisting the court.
Lordship.
Yes, yes, my
Lordship.
lord, there is, my lord, in fact, my lord, there were two elements. One was, my lord, overcrowding in prisons. And another was, my lord, to fill in the vacancies. My lord, which are, my lord, in the police force, my lord, and my lord, in the correctional homes. My lord, there are two aspects. I think this public interest litigation, my lord, has more to do with, my lord, crowding, my lord, in prisons. There was another public, well, suo motu again, my lord, which related to, my lord, my lord, filling up of vacancies. Both, my lord, can be taken up because
No, you separate it. You make a chart. What is the prayer writ petition number? What is the prayer? What is the step taken? Instead of going pages after pages. So this filling up of the staff vacancy, I mean police vacancy, that can be dealt with separately. And we can fix a time frame, or you can tell this is the time it will take for recruitment. Suppose promotion posts are vacant, promotions can be affected.
correct.
So that can be.
And may,
Then overcrowding, how many are under trials? How many are convicts?
My lord, first is capacity. Then, my lord, how many, my lord, are
That
convicts?
data is there in the.
Yes,
system.
yes, my lord, it keeps, my lord, coming, my lord. The thing is, my lord, our state's performance, my lord, up to 2021 has not been good. My lord, my lord, be candid, my lord, in, my lord, making that submission. My lord, the way the affidavit has been filed, my lord, it is saying a lot without disclosing anything. So, my lord, I need to,
No, it
there's
should
no
be,
point.
it should be concise, sir. They are
Correct,
writing
correct.
reports, 15 pages, 20 pages. It's
My lord, I don't want to, my lord, go
No,
into.
what about the vacancy position?
My lord, both. My lord, steps are being taken. Now, my lord, steps are being taken is not, my lord, good enough. My lord, we must know this is the vacancy position. These are the posts. These are the promotional avenues available. These are, my lord, where
You
recruitment.
please be specific on that.
Yes, I have.
And in all the now it's called correctional homes. In all the correctional homes, so what is the sanctioned, approved strength, and what are the number of inmates? Out of the inmates, how many are under trials? How many are convict prisoners? How many people are on bail, unable to comply with the condition, not a window? How many people are there who are charged or arrested on account of illegal immigration, who have come into the country without papers and they have been lodged in the prison? And whether they are ladies, whether they are, then any health condition, some people, and people who are still in prison, charged of offenses under the narcotics and psychotropic substances. How many are foreigners? And how many foreigners, their bail plea though was granted, they are unable to furnish security, or you make a chart on that.
Yes.
Some homework, this bulk won't help. Sir.
my lord, only one indulgence, lordship. Only in the
No,
year.
this entire file contains only order sheets.
Yes.
What have we been able to do with this? Nothing at all. It contains only order sheets.
Something happened during this period. My lord, I cannot
Lordship,
say, my lord, nothing happened.
Appointed in this matter.
Please.
Your lordship, that's rubbish. It's rubbish.
The Honorable retired Chief Justice of Supreme Court, R.C. Lahoti, who moved this matter, that in the form of that friend of the people, and thereafter that letter was treated as public interest.
Public interest.
Chitrabayan is released.
Honorable Justice, Honorable Justice, Madan Ji
এখানে এসেছিল
and Honorable Justice Deepak Gupta, they passed one order. And they requested all the chief justices of all the high courts to initiate suo motu matter. And thereafter,
This is
saying that that issue, that there are 4 issues, One is overcrowding in prison. Number 2 is unnatural death of prisoners. Number 3, gross inadequacy of staff. And number 4 is available staff being untrained. This staff, in this matter, this Honorable High Court already passed one order 9/7/2018 that fill up all the package. 9/7/2018.
Lordship,
There are
MD Abhinada,
71
mic is queuing.
And the number 1.
No.
Number 1 is that that unnatural death in prison. And that compensation from 2012 to 2015 has to be given. Today it is not given. Today it is not given. That 2012 to 2015. But thereafter also it takes place, that compensation.
You give that judgment?
Yes.
Unnatural death, my lord, is alarming in our state.
No,
And 71% my lord, still incarcerated in jail for non-payment of fine, my lord. And we have, my lord, enclosed with this particular report, my lord, all such data.
Lordship,
That judgment, I think, is in the compilation which has already been filed.
Lordship, I am another mic is queued in this matter. Lordship, I have pointed out certain things.
Wait, first of all,
Lordship.
there is no consolidated
Yes.
data here for us to do it. Because I have attended more than 3 conferences after coming here,
Yes.
conducted by the National Legal Services Authority. On the national scene, our position is very, very poor.
Yes.
Very poor.
Yes.
So I know that data. We were confronted with that data. And in fact, the former Honorable Chief Justice Prakash Srivatsav was also attended that conference. Along with another 3 honorable judges were there at the conference. I know some information about it. Let the state come forward with that information. Because at one stage, when I had meetings with the ADJ, correction.
I was there in one of them.
One of the meetings, I mentioned about it. Thereafter, I think, what is his name, Mr. Piyush Pandey.
Piyush Pandey, my lord.
Piyush Pandey.
My lord, he's no longer there, my lord. He's being shifted to security.
Security is gone. Piyush Pandey sent me a lot of these brochures, not brochures.
Which your lordship sent across to me before I took a precipitate step.
So
telling me not to get angry.
And containing photographs, people dancing, this, that. Of course, we met one of the senior artists. I forget her name.
Alakananda Roy.
And I met her. She came for a discussion. And I met a couple of psychiatrists and
clinical
psychiatrists,
psychologists, my lord.
And they are all being trained by one doctor, psychiatrist, who hails from Chennai. She is going to be here in the International Psychiatry Conference, which is going to be held in Calcutta next week. And there is one organization which is called Sneha, which helps people who are depressed just before the 10th standard examination, board examination. And what happens in all the news reports, which contain reports about the death by suicide, the helpline number is given. Here I requested Times of India, they have not done. Hindu, I don't know. They have other papers they have not done. I asked those 2 psychiatrists. They said in West Bengal, the press is not willing to publish the helpline number. So therefore, we'll ask the AG to.
My lord, we have, my lord, collected certain, my lord, documents by way of RTI in our report. Let this report be, my lord, countered, or my lord, some addition be made. Well, I have circulated
Sir,
this.
at times, the information officer, whatever he furnishes is half-baked.
Yes.
Is half-baked information.
Lots.
Then you'll have to file an appeal. Then you have to go to the commission. So it is
Well,
the
it's-
state's duty. See, they are not, respondents fighting the litigation.
Yes.
Jail administration is sensitive. So far, this RTI, my lord,
One-
reply is concerned, my lord.
One
I must
aspect,
accept and admit it, my lord.
Lord, I know, my lord, every inch of all the prisons, my lord, every inch, because in the year 1990, I was appointed as special officer to remove the plight of the prison. So since then, I'm doing some research work. So I know every inch.
So your presence will help us.
Yes.
We will pass a short order. Give to Learned Advocate General 2 or 3 weeks time. Let you please come with a spreadsheet data.
yes, the way your lordship is.
One more thing, my lord, I'm telling your lordship, my lord. Recently, I had visited, my lord, one presidency correctional home, my lord. There, my lord, all the, my lord, that ex-education minister and all the VIP prisoners are there. And that superintendent, my lord, they are doing, my lord, CCTV surveillance on them. And, my lord, it's violates the human rights. Absolute right. I'm filing this.
No, we will not take it under account.
Yes,
We will not take it.
absolutely.
You are an amicus curiae to assist the court on the common issue. We are not concerned about VVIP prisoners or VIP prisoners. We are not concerned.
No.
It is up to the VVIP concerned. It is, no. Who are you to canvass this case?
No.
It is up to the VVIP prisoner to say that his privacy has been invaded. We are, no. I'm very sorry, sir. Very sorry.
Your lordship kindly
Please,
see the
we-
alternative.
Lordship, kindly, the way your lordship has indicated the.
Please hear me out. In order to ensure that effective directions are issued in this suo motu proceedings and the connected matters, we would require the state to submit the relevant information in a concise tabulated format by avoiding lengthy affidavits. The Honorable Supreme Court, in the case of inhuman conditions in 1382 prisons, 2016 3 SEC 700, pointed out 4 issues, namely 1, overcrowding in prisons; number 2, unnatural death of prisoners; number 3, gross inadequacy of staff; and number 4, available staff being untrained or inadequately trained. Therefore, the tabulated report to be submitted by the state should cover these 4 aspects of the 4 issues pointed out by the Honorable Supreme Court. Apart from that, the information should also disclose as to how many prisoners are under trials, how many are under trial prisoners within bracket UTP, how many are convict prisoners, the number of male and female prisoners, the prisoners who are confined to the correctional homes having been charged of offences under the Narcotics and Psychotropic Substances Act, charge of illegal immigration, the number of prisoners who are of foreign origin, the required information where prisoners who have been granted bail, unable to satisfy the conditions of bail, who are still languishing in the prison. A separate report should be filed in respect of the facilities which are provided in the various correctional homes in the state. The learned advocate who has intervened in the matter submits that he has collected certain information by raising queries under the provisions of the Right to Information Act. Let those let such information be furnished to the Learned Advocate General so that the same can also be taken note of while preparing the tabulated statement in terms of the above direction. After the information is furnished, the court will deal with the various issues in seriatim one by one.
Only, my lord, the person who are waiting for death row, and whether they are in compulsory solitary confinement, that is also to be, my lord, taken into consideration. Because unless it is confirmed by the Supreme Court and thereafter clemency and all this, my lord, they should not kept in solitary confinement. That issue is, my lord, the dark issue. So far, my lord, this.
I think in this data itself, that should come.
Maybe, my lord, can
Your Lordships may make a specific mention. of
online
uh,
direction.
as suggested by the learned advocate for the intervener. You are the intervener or
I'm intervener, my lord. I
as
draw lots of
suggested by the
attention.
learned advocate intervener. Advocate hyphen intervener. The information to be supplied by the, to be submitted by the state shall also give the details of the convicts in the death row.
Whether they are in compulsory
Whether
or
they are
solitary
in
confinement.
solitary confinement or not.
That is not permissible, lordship, my lord.
So,
And this is the way of filling up of the vacancies order.
the information to be furnished by the state shall also include the information to be disclosed shall also mention about the number of cases in which appeals are pending before this court, either at the instant of the prisoner, convict prisoner, or by the de facto complainant, etc. No, only by the convict prisoner. And the report shall specifically state about the number of vacancies in various category of posts and the steps taken for filling up those vacancies. The report shall also mention about the medical facilities which are available in the correctional homes, presence of psychiatrists and whether psychiatrists and clinical psychologists visit the prison, and other facilities, other activities which are there in the correctional homes, so that the prisoners can be engaged throughout the day. I think there is a furniture.
Compensation of jail death, my lord, issue is an important issue so far.
Will come, sir. Everything you can't bottle up.
Lots.
And how many correctional homes have got these activities? No, activities.
My lord, that I'll haven't, my lord.
In fact, Mr. Piyush was mentioning there is a carpentry unit, etc.
Correct, my lord. In fact, my lord, sitting in the committee, my lord.
I told.
Because I had lost my temper, my lord, at the meeting. Your lordship sent me, my lord, the brochures.
Open jail is there, my lord.
My lord, may I?
Next time when you go to Chennai, you tell me. I'll ask the DGP presence to take you to one of the finest open jails in Southeast Asia.
And compared to that, here number is less, my lord.
My lord,
Chennai and in the other states also, my lord, open jail concept is, my lord, is a popular.
For which you require land.
Lordship.
My lord, may I just
And my lord, super.
My lord, may I just seek one indulgence? My lord, the order of the Supreme Court your lordships referred to, my lord, is it, my lord, of 8th of May 2018, my lord? That's all, my lord.
No, this is reported decision, sir.
My lord, the date, my lord, I just wish to see, my lord, because all the.
That's all. Next date, we'll ask you sit down. The data also shall include details of the diet given to the UTPs and convict prisoners, as to whether they have been maintained and whether the kitchen and the dining areas are neatly and hygienically maintained. The concerned authority shall also submit photographs of the correctional homes where to have first-hand knowledge of the facilities. In fact, in Murshidabad, there was a complaint. Sit down, sir. There was a complaint which has been forwarded. Before Justice Jaimala Bakshi, when the bail application came, he said inhuman conditions. I think it's something happened. He called for a report, and that report was placed before me. They found lot of issues. Then we said, and especially diet. There's a beautiful menu card there, but nothing in that card is given. Weekly thrice, they have to give some egg and chicken, etc. So if you have some activities, sir, it will be very good. But Mr. Piyush said, sir, there's some activity.
They
In
have
fact,
made canteen in all the prisons. Canteen system and beautiful food supplied there.
but that food is supplied for whom?
Those who have money.
No,
Those who have money.
that is the prisoners.
Yes, prisoners, those who have money
No, it should cater to the public.
should be for everybody. That is not being done.
No, that's called the prison bazaar and the prison hotel.
Yes.
And in a lot of districts in the state of Tamil Nadu, this prison hotel and bazaar is there. Prison bazaar sells everything, rice from millets to vegetables to bread, etc. And in the bazaar also has a separate, because they got a tailoring unit, all types of dress, cloth, bags. In Madurai, there is one district called Madurai. It is the convict prisoners who serve. The bazaar, the hotel is outside the prison. The 100 feet wall is there. It's outside the prison. They don't run away anywhere.
They get away. They get away.
They make the food. They sell the food.
And one more thing, Lord, I am telling you, Lord, that all the buildings are British made. So condition is very bad. So this is British made, but the maintenance is here. The maintenance is there, but their maintenance is not there.
There no maintenance.
That's a dumb building, and all prisoners are during the rainy season. During the rainy season, all prisoners are
How many courts are leaking, you know? I can at least name 4 districts where the courts are leaking. In North Chowkis, the entire rack server got burnt out because of water seepage.
At night, they cannot sleep together. That's the problem, because of overcrowding.
Lord, I just seek one indulgence. My lord, there was an affidavit I filed, my lord. It related to a query raised by this honorable court, whether, my lord, an Indian national who'd been convicted, my lord, in Bangladesh, my lord, had been released, my lord, after the Supreme Court of Bangladesh, my lord, acquitted him. My lord, that has happened, my lord. I just want to put it on record, my lord.
What is the date of the order?
My lord, the date of the order is 21st February 2023.
You get taken and give no help.
My lord, my lord, the report says that, my lord, on top. My lord, your
The-
lordships need not look at the order.
By order dated 21st October,
February.
21st February 2023, the Learned Advocate General, 2023, the Honorable Division Bench recorded the information submitted by the Learned Advocate General that the process to release the Indian national convicted from Bangladesh court is on, and the same will be completed within 1 week.
My lord, this is, my lord, what has been.
An affidavit, what is this, sir? Report or
My lord, report.
a report in compliance with the order dated 21/2/2023, dated 6/3/2023 has been filed by the superintendent, Bariyapur, is it? Bariyapur Central Correctional Home, West Bengal. Stating that the said convict, namely Chitta Gayan, was released from the said correctional home on 21/2/2023. The report is placed on record.
This is made returnable.
Next matter is mine. I thought I will respond.
You are not to be seen, Mr. Bhattacharya.
I was trying my best to
You didn't log in the other day.
I was trying my best to get in touch, but unfortunately, system failed.
Our system didn't fail.
I feel sorry for that.
Your junior colleague system also didn't fail.
Yes.
Your system failed.
My system failed. Now, the next matter is my matter.
I'm for the respondent 14, my lord.
Take it up on 24th because I'll be out of town for entire period.
Yes, my lord.
16, 17, 18, 19, is it?
I'm for the 16 and 19. I'm for the private respondent.
16 to 19 at the request of Mr. Vikas Ranjan Bhattacharya, Learned Senior Counsel for the appellant, list the matter on 24th or after 24th?
24th.
On 24th. AG, previous matter.
My lord, kindly give us at least, my lord, 4 weeks, at least, my lord, I might, my lord, to. My lord,
List
my lord, kindly make it 5,
We list the dates. 15th May,
very well, I'm grateful.
list in the daily list.
Segregated, matters may be.
My lord, item number,
That is why
2 reports.
they will give the report. First, we will address the vacancy. Next is infrastructure, overcrowding, then facilities. Then what are the types of prisoners, what has to be done, etc. We will segregate it. And each of you address one issue.
my lord, item number 20, my lord, I am the special officer appointed by this honorable court. But tomorrow, my lord, I will not be there, my lord. If your lordship kindly takes up, my lord, on 17th or 18th, my lord, on the last occasion, it was adjourned because of my absence, my lord.
My lord, in
I-
this matter,
My
my
lord,
lord,
in-
happened on behalf of the national,
National highways, my lord. My lord, I have been appointed to ensure that the four laning of national highway from here till Assam Bengal border is implemented. But I have also circulated report today. That is my 11th report. My lord, I'll want to
You
place. it-
furnish copy.
I have already.
lordship, in this matter, lordship, I need another 2 weeks time, lordship, to file our reply, lordship, in terms of the,
The learned amicus has filed a report, copy of which has been served on the advocates
your lordship, I am for the NTPC Limited, your lordship.
for the respondents. Respondents.
With-
The learned advocate appearing for the National Highways Department seeks 2 weeks' time to file reply.
The report filed by the special officer, lordship.
To the report filed by the special officer / amicus. List the matter on 24th April.
24th, my lord. Split on the higher up in the list, my lord.
24. 20. Yes. What about item 21? AG is there?
21, my lord, is I am appearing for one of the petitioners, my lord.
Recruitment.
That is, my lord, that is with regard to, my lord, the matters, my lord, the orders passed by the state administrative tribunal was challenged initially. Now, my lord, it surfaced that the Honorable Supreme Court had issued a direction upon the Honorable High Court that with regard to recruitments in post of constables, the High Court should take up the issue. Now, my lord, when that order was brought to the notice of the Honorable Division Bench, taking up, my lord, regular determination arising out of the SAT.
So they.
So this has come here, my lord. That is an emergency, my lord. That is very urgent, my lord.
So let it remain in the list.
Yes,
Tomorrow, my lord, I will not be there, but in any case, someone else will be there.
Other councils.
My lord, and my lord, this national highway matter, my lord, I was, because the monsoon is coming, again, accidents will
24th.
happen.
24th.
24th April.
I would be, yes, I'll be making certain prayers. Diplo.
Lordship leave, my lord, to file 3 appeals with the server copy, without the certified copy.
Date of the order,
23rd of March.
leave granted.
Grant. My lord, one more. I'll wait for my.
Yes.
But may I mention item number 19 and 20 of the days list?
Ah.
In these two matters, I'm led by our outstation senior, Mr. Ravi Kadam.
Okay.
So I was requesting it not today. But the learned ASG is on the other side.
He has some difficulty this week, my lord. He has asked for the next week. So we have agreed upon a date on 19th of April. If your lordship, my lord, agrees, my lord, then we shall.
Item 19 and 20.
19.
And 20 at the request of the learned advocate. At the request of the learned advocate for the appellant, list on 19.
19.
Can it be fairly on the top, my lord? If it's
It is fairly on the top.
Lordship,
Almost it is.
Obliged, my lord.
Lordship, may I have your kind leave to make
19.4 in the same position.
my lord? My one matter, my lord, it pertains to transfer pricing issue is involved. And matter already was in the list and was returnable on 16 February. Due to the time constraint, your lordship cannot take up the matter. My lord, Mr. Parsi Pardiola is appearing. My humble prayer before your lordship, kindly take up the matter on 3rd of May, because the next month I am praying for that. In that meantime,
One thing, we are yet to settle down with the current determination. Let us run for 2 weeks, then we will inform.
after 2 weeks, I will mention, my lord.
Yes.
May I have your lordship's kind leave to mention a set of 5 appeals, my lord, which was taken up by the Chief Justice on the 17th, and thereafter in view of demitting office, when he said that will appear tomorrow, 11th. These are residuary appeals, my lord, for
Hearing matters.
consideration of interim order.
No.
Tomorrow is 11th, so what I was respectfully submitting,
The appeals were against an interim order or?
no, appeal were against orders by which a writ petition was disposed of. There were 5 separate writ petitions by a common order. It was all disposed of. So we are in appeal, 5 separate appeals against that common order. So when it was taken up, the
Oh,
honorable
it is taken up for admission or what was it?
at the admission stage.
Okay.
says
Then you give the number. We'll
Yes,
list
my
it.
lord. My lord, if it could be 5 of them are there, it was directed to be listed on 11th. Your lordship can list it any day convenient to your lordship.
Oh, it's on 11th April. That's tomorrow.
Tomorrow. So my
It
lord,
will come on 11th April.
very well. Tomorrow, my lord, there is no original side in the residuary subject to correction. So my lord, kindly keep it on the week starting 17th.
When it will come? Don't.
You will check.
We can list it tomorrow. There's no issues.
Very well, your lordship list
Let
it
it come
tomorrow and then
tomorrow.
we,
We'll
very
see.
well, very well.
But the original side we won't take up tomorrow. We
Lord,
will
this
take
is
up.
the order.
Original side.
You will know.
So Wednesday, let it come on Wednesday. Wednesday.
Right. Well, subject to, well, we'll put the other side on notice as well.
All right. All right. Tomorrow it will be published, taken up on Wednesday.
Or my lord, if it could be taken up on the 19th.
Somebody make request on Wednesday.
Very well.
Let it first get into the list.
Very well. Very.
That's the most important part of it.
Very well.
My lord, may I be permitted to mention a matter, my lord? This pertains to the circuit bench at Port Blair, my lord. We have preferred an appeal, my lord. There is some urgency in the matter, my lord. Hence, we were requesting if it can be listed, my lord.
So when is the circuit?
Circuit starts from 17th, my lord, the Monday. There is some urgency in the matter, hence we are mentioning.
You have been able to manage this long. You manage for a week.
There is a direction
Even assuming we included today, item 1 went on till 12:30.
My lord.
We were able to push only 10 or 11 matters. There is no purpose in including in the list. It won't reach. So for a week you manage and move the.
Grateful. My lord, may I be permitted to mention, my lord, there are 2 matters, my lord, in which the orders may require some corrections. My lord, this is ITAT 65 of 2023. I'm handing over another. My lord, mark the changes in pencil.
They named you Amit Agarwal.
Yes, my lord.
This matter has been listed under the caption to be mentioned. It is pointed out by the learned advocate for the respondent. In 2 places, his name has been wrongly mentioned. He said that mistake be rectified and the correct name of the council
Yes.
is mentioned in both the places. And this order shall form part of the order.
My lord,
24th March 2020.
my lord, if I, my lord, there is one more correction, my lord, if I may kindly point out, my lord, at the top of at the cost title, my lord, it should be ITT 65 of 2023, my lord.
Yes, my lord. ER is strongly
Before that,
printed.
it is pointed out the name of the number of the case has been shown as ITAT number 65 of 2022. However, it should be ITAT 65 of 2023.
Yes, my lord. My lord, there is another matter, my lord. My lord, this is ITAT number 10 of 2021. My lord, I'm handing over the copies with the proposed corrections. My lord, this pertain to assessment year 12-13. If my lord will kindly go to page number 4. My lord, I've made the change in pencil, my lord. It should be, my lord, 2007-8 and 8-9, my lord, because
12-13 is not there.
Because 12-13 is this assessment year, my lord.
Only 2 corrections.
Yes, my lord. At page number 4 and page number 7, I have marked the relevant portions.
This matter has been listed under the caption to be mentioned. It is pointed out by the learned advocate appearing for the respondent that in 2 places the financial years have been wrongly mentioned, namely in page number 4 and page number 7. Financial year / assessment year. The correct numbers, correct years being 2007-8 and 2008-9, and 2012-13 be omitted. The said correction be carried out both in page number 4 and 7 of the order dated 3rd April 2023, and this order shall form part of the order, the said order. Yes. Today's order you have to record Mr. Tilak Mitra, Soman Bhattacharya. Please call the list.
Specially assigned matter, serial number 1, Sanjay Kumar Bajoria.
My lord, this is my appeal.
What is this specially assigned?
Yes, my lord, this has
We
been,
have seen assigned matters.
Opposing this, my lord, appeal.
my lord, before I go any further, my lord, this is basically an order whereby my plaint has been rejected on an order 7 rule 11 application, my lord, and without taking my averments to be true and correct, my lord, the honorable judge has proceeded to go into the merits of the matter and dismiss.
But where is the assignment order?
কিভাবে মামলা শুরু করে দিচ্ছেন নাকি? না, yes.
What is civil matter?
না, আমার এগেইনস্ট নেই, তোমাদের এগেইনস্টে আছে। আমরা কার হতে পারি?
So we don't have the determination now, as of now.
I think, my lord, some of
Will
the
not see the
correction
companies.
on
Yeah,
a prior occasion.
this was taken up. Yes.
Cited over by my lord Justice I.P. Chief. His lordship was used to observe that for personal reasons he could not.
Released.
Where
No, my lord, thereafter it has appeared before your lordship's list, my lord, on one occasion.
Yes,
Some of the
come up on 12th August.
Yes.
Some of the defendants will not have been told, my lord, that there were no cause of action, so their names have been
Yes.
deleted. That's what, my lord, the suit. That's
My lord, the
if you're not.
rejection in part of my plaint, my
Not
lord, against that I
rejection.
am coming up. Now, my lord, may I make one request? My lord, Mr. Jishnu Shaha is leading me in this matter. My lord, I was only praying if it could be fixed up on a particular
Now,
date.
suppose the matter was not released by anybody. Which division bench will have the determination as of now?
My lord,
Lord,
as of now, Justice
Appeal from
Tandon,
orders,
yes.
my lord, would have been.
Yes.
Justice Tandon has released the matter.
Yes, my lord, Justice Tandon has released the matter, and my lord, thereafter, Justice Mukherjee's bench has also released the matter. My lord, both the division benches have released the matter.
On personal grounds.
Yes, my lord, both the benches have released the matter.
We are going by the present determination. I don't think so. We will be able to hear this matter
Well,
finally.
anytime, my lord, convenient, my lord, will.
No, there will be never a convenient. We are not able to move this, push the admission list. And I am told, it's new to me, that fresh cases don't get listed unless it is Judicial intervention. What is this judicial intervention?
I don't know, my lord. It's supposed to, my lord, if a date is, my
That's
lord, that's what, as far as I know, my
They
lord.
told me, but in the original side, in our earlier determination, if you on this
Put in the dates, then it would have come on that date. Correct, absolutely.
and here morning 15 people are mentioning it's a fresh case, include. It's news
If
to
the
me.
dates is given, then, my lord, it comes up generally.
Yes, it generally
It
does.
should, no?
It generally comes
It
up.
should.
It
You
generally
tell
does.
the appellate side.
Yes.
It should come.
Yes.
They shouldn't be queuing in here and saying, sir.
It's only, my lord, when it's urgent, my lord,
Yes.
sometimes, my lord, we come and mention. Otherwise, my lord, dates are given and, my lord, it comes up.
It's a matter where some affidavit is called for or somebody adjourns the matter. It's gone out of the list.
That is.
This is called date of proceeding.
Division man.
We will assign it to some other division.
If that is, my lord,
Because let it
convenient.
be.
Otherwise, I'm sure,
My
my lord,
lord,
you got to
before doing that,
come
my lord,
back in
may I
June
just
also.
indicate, my lord, the impugned order is of 2010, my lord. My lord, we are standing in 2023.
And what is the subject matter?
My lord, the subject matter, my lord, the entire thing is that we have filed a plaint, my lord, where we have claimed that a joint venture agreement had been entered into. And my lord, we were seeking the benefits which were agreed to be actually enforced and given to us. Now, my lord, there are several companies that are, of course, involved. And my lord, on that basis, my lord, by the impugned order, my lord, the companies were found to be added unnecessarily. Their names ought to be struck out because no cause of action, the honorable judge held, was disclosed against them. My lord, and my lord, while holding the same, my lord, the honorable judge ventured into the merits of the matter and also decided the matter partly. My lord, that is where we have been aggrieved. Of course, my lord.
Correct, obviously.
Of course, my lord. My lord, my plea was essentially, my lord, the averments in the plaint. My lord, this is a settled principle of law. In an Order 7, Rule 11 application, my lord, the averments in the plaint have to be taken to be true and correct. And my lord, the court will not venture into a roving inquiry to find out whether the pleas that have been taken will stand the test of trial.
Statement of law is right. How you apply it to facts.
That's
Yes,
right.
my lord. My lord, we will. My lord,
Correct.
my lord, we
Lord,
have
absolutely.
sufficient
Due to personal reasons, one of us, within bracket my name, is unable to hear this matter. Therefore, the matter stands released. Let the papers be placed before the Honorable Acting Chief Justice for appropriate assignment. Yes, I'll do it today.
very well.
So that it gets listed as
My lord is not inclined, my lord, to take up the matter.
So if we take up, we should finish.
I know that, my lord. I know that. My lord, we have some.
I am stuck with one matter. You are a party to that. So
My lord, that is a matter, my lord, which is totally different matter, my lord, from the rest, my lord, whatever, my lord, we are.
Anyway, thank you.
Grateful.
Two, Otanu Chakraborty.
I appear for the High Court administration.
2 and 3 are connected. This is that selection.
Yes, Lord, this is Lord relating to appointment, Lord, in the judicial service, Lord, in 2009. The writ petition was.
This is also specially assigned.
Yes, Lord.
And who appears for the appellant?
Mr. Shamanto, Surojit Shamanto, I think. I don't see him today. The problem is here, many benches, Lord, have released this matter.
That's different. But today you are appearing for the appellant.
My lord, I am appearing for the appellant.
Yes.
My lord, I am being led by Mr. Surojit Shamanto. Is not present in court today, my lord. Kindly.
No, we saw this under the caption specially assigned. So we wanted to know what is this specially assigned.
Read it as assigned, not specially.
It's given a. All right, when you will argue, because
my lord, may keep it next Monday.
Next Monday.
Specially assigned, my lord. We'll argue the matter.
The writ petition has been dismissed. The order is against challenging that order of dismissal, the appeal. is challenging the order of dismissal. But my lord, there are certain observations made with regard to the High Court administration. Therefore, my lord, the High Court has also preferred a cross objection. So these are, my lord, 2 is the main appeal. And
What is the subject matter?
subject is, my lord, there was a selection
Ah.
of my lord, in the cadre of district judge. And my lord, while selecting, my lord, there were concession given of 2 marks by the selection committee. The full court, my lord, approved it. After that, these appointments were made. These judges were working. After 9 years, my lord, this writ petition has been filed. Prior to the filing of the writ petition, say Article 32 was filed before the Supreme Court, which got dismissed. And my lord, after that, this writ.
And who is the writ petitioner?
Lord, he is one of the, my lord,
Applicants.
he is one of the candidates who had applied but unsuccessfully. He's an
What are you going to do now? 10 years, 10,
Yes.
12 years before, and some of them would have been there in the bench.
Yes.
My goodness.
My lord, I would prefer my senior to argue this matter at length, my lord. My lord, kindly keeps it on Monday.
And what is the name of the writ petitioner?
My lord, the writ petitioner is Atonu Chakraborty.
Atunu Chakraborty. He is here,
Is not here, my lord.
but he also practices here.
Oh, my lord, I wouldn't know. I really
He
don't.
practices here.
My lord, I'm not sure. I am just appearing this day, my lord.
I think he is in service. In all probability.
Who is in
I'll-
service?
Yes, I'll check up on this. I'll check up on this.
Your client is very serious in contesting this matter. All right, if he wants, let him contest. Some reasonable time should be there, no, for all.
At page 41 of this paper book, volume 1, your lordships will find he says he is affirmed it as he is in service by occupation service. So he must be.
Oh, he is in the West Bengal Judicial Service.
Is in West Bengal Judicial.
And where is he now?
My lord, I'm just appearing this day, my lord. I'm not instructed in this.
Let the matter be listed under the same caption, in the same position, on 17th April.
Grateful.
Much obliged.
Four, the state of West Bengal and others.
Here I appear for the respondent to the escheat matter, lordship may recall, where they wanted to vest the port trust's property as escheat. The court set aside.
Yes.
Unruly horse.
Unruly horse.
Yes.
This lordship, this is nothing there. They're only taking adjournment. Fix it any day, make it peremptory. Because
Yes, your
this
lordship,
can't
next
be-
week. Next week, lordship, any day.
It will come in the monthly list of June. May we have got only hardly 2 weeks. Since the matter has to be finally heard.
Yes.
And the appeal cannot be taken up this month due to want of time. Let the matter appear in the monthly list, combined monthly list of June 2023.
Deeply obliged.
Five, LMJ International Limited.
My lord, I appear for the appellate, my lord. My lord, in this matter, my lord, led by Mr. S.N. Mitra. My lord, he is in some difficulty today, my lord. Kindly adjourn it for a week, my lord. Let this matter be taken up next Monday on 17th.
All right.
I appear for the plaintiff, respondent number 1.
I am appearing for respondent number 2, my lord.
Your lordship had the occasion to consider this matter not extensively, but
Why was the matter specially assigned to this bench?
My lord, it was released by one of the bench, then it was assigned to your bench, my lord. Your lordship was sitting in court number 16 with Justice Bhattacharya, and your lordship has heard this matter.
We heard the matter.
yes. Extensively, your lordship was pleased to hear this matter. That matter were regarding whether if a plaintiff goes into liquidation, whether there is requirement of any substitution to be carried out separately or by operation of law, the plaintiff. That's it.
This is the point, yes. Yes, my lord.
This month may be difficult. Because if one matter is taken up, it will at least 1.5 hours time for Oppo. Let it come in June. I jointly pray. Okay, we'll combine. Next.
Tax matter, new application. Item number 6, Principal Commissioner of
This is
Income
the
Tax.
appeal filed by the appellant CIT, my lord. Subject to your lordship pleasure, we have filed an application to state that what happened after taking over of the management of this company, present SSC, my lord. But that application, Mr. DN Sharma is appearing, he is suffering fever today, my lord. My lordship takes up day after tomorrow, my lord, Thursday.
That application not listed.
The application is not listed, my lord.
Volume 2, volume 3. What is the prayer?
My lord, your lordship may recollect that Binani Cement was there. They are failed to comply the debtors payment, my lord. That is why there is an NCLT pass an order when this SSC Ultratech made the proposal for taking over the management, and that was granted, my lord. During the pendency of this appeal, my lord, this has happened, my lord. We want to submit before your lordship what has actually, whether this appeal can be proceeded with or not. That has been very much clear in the order.
Then you serve a copy of
I served the copy, my lord.
and you file your affidavit or get instruction.
No, rejection.
Instruction you can get. If not an affidavit.
But they are also party before the NCLT, mother.
The
give a small direction if there is any affidavit we file.
we have heard so also. The learned advocate appearing for the respondent submitted that the respondent has filed an application in GA number
3 of 2023, my lord.
G of 3 of 2023. That's listed. So 23, bringing certain facts on record and would submit that the revenue cannot pursue this appeal. The learned standing counsel for the appellant prays for time to get written instruction in this regard, and if necessary, file an affidavit in GA number 3 of 2023. Let the matter appear in the combined monthly list of May 2023.
Copy.
May.
Deeply uplifting.
Service course.
7, Principal Commissioner of Income Tax 5.
My lord, this is my application. There is a delay of 166. I've already served, but it has returned back as undelivered, your lordship, with an endorsement.
What is the endorsement refused?
As addressee cannot be returned to senders. I really, it's not.
How many? 166?
Yes, my lord, 166 days.
We have heard Ms. Smita Das De, learned senior standing counsel for the appellant. The notice sent to the respondent has been returned answer with a postal endorsement which is not very clear. In any event, the delay is 166 days, which has been properly explained. Therefore, we exercise discretion and condone the delay in filing the appeal. Applicant petition allowed. The appellant revenue shall intimate the assessee that the appeal will be heard for admission in the monthly list of May 2023. You send by email?
Yes, my lord, deeply obliged.
8, Principal Commissioner of Income Tax 9, Kolkata.
8, 9, 10 for the different only, the same SSC, my lord, but only the assessment years are different. And there's a delay of 168 in all the matters, my lord.
That we can condone. What is the issue?
Yes, my lord.
My lord, may kindly take it up on the next number. My lord, we just received the paper.
No. It's a public sector undertaking.
Yes, my lord.
What is the
It's a
issue?
cooperative
society. Where is the question of law?
Page 6, my lord.
14A is covered.
14A, that's an additional ground which has been taken by the SSC. Whether it is a stock in trade or it's an investment, that the dealing with the sale and the investment of the equity and the mutual funds, that is the issue before your lordship. So whether that will attract 14A or not. Tribunal's order starts from page 55, your lordship, at 61 is the.
Smita, you come to page 59, para 7.
It is true that the principles of the res judicata is not applicable in the income tax proceedings. However, in this case, we know that the revenue has consistent. Yes, my lord, this is a consistent practice for the earlier assessment years. They have got the deduction. Yes, my lord.
One AO wakes up at 6 o'clock and say, this year I am going to defer. Let him do that. Let him do it with proper material. 14A is covered. Someone will finish it up.
Because just on the basis of that, the assessing officer has
Obviously,
already
in the
arrived at a finding
No,
for
in
the
this
earlier assessment years.
public sector, they won't apply that. Whatever they are doing year after year, they will keep on doing. And year after year, you have accepted it. And the res judicata is not there.
Suddenly one fine morning, they come up and they take up an issue.
And in
That's
1 year, they deferred 11-12, CITA has reversed that order. So
They've not even filed any appeal.
appeal against the rule of consistency. You have heard who's appearing? Senior is appearing. Huh?
no, he's
No, madam.
You are appearing.
Uh-huh.
Heard Ms. Smita Das Kejriwal. There's a delay of 168 days in filing the appeal. We have perused the affidavit filed in support of the petition and we find sufficient cause has been shown for not preferring the appeal within the period of limitation. Hence, applications are allowed. Delay in filing the appeals are condoned. These appeals have been filed by the revenue under section 260 capital A of the Income Tax Act 1961, within bracket the Act, challenging the common order dated 18/4/2022, passed by the Income Tax Appellate Tribunal B Bench Kolkata in ITA number 426 to 428/KOL/2020 and 268 to 269/KOL/2021 for the assessment years to 2012-13. What are the other 3 years?
Madam, 13, 14, 14.
14,
14,
15.
15. The revenue has raised the following substantial questions of law for consideration. Page number 6, sir. Question number A, B not required. C and D. We have heard the songs. The first issue which arises for consideration is with regard to whether the action of the assessing officer in accepting the assessee's treatment of the income from the sale of mutual funds and shares as income from business should be accepted. The learned tribunal has affirmed the view taken by the Commission of Income Tax within bracket appeals and has specifically noted that the department is required to maintain a consistent stand on the issue, which was a recurrent issue, and a departure can be made only when new fresh material is available to do so. we find that the revenue has consistently accepted the stand of the assessee that it is a trader of shares and mutual funds from the assessment year 2005-6 to 2007-8. And in the year 2008-9, the assessing officer deviated, which order was reversed by the Commission of Income Tax Appeals. Subsequently, the assessing officer has again treated the assessee's action as a capital gain for the investment from the investments for the assessment year 2011-12, which was reversed by the CITA, and it was held to be business income. And that order passed by the CITA has not been challenged by the department and allowed to attain finality. Thus, the tribunal rightly noted the decision of the Honorable Supreme Court in Radhoshomani Satsang versus CIT, page 59. 1992, 193 ITR 321 within bracket SC, and held that the rule of the principle of rule of consistency has to be applied in the assessee's case. Thus, we find that the order passed by the tribunal was just and proper and does not call for any interference. The second issue is whether the order of the assessing officer disallowing the expenditure by invoking section 14 capital A of the Act, read with rule 8 capital D within bracket numerical 2 within bracket 2 I's and 3 I's of the income tax rules 1962. On going through the order passed by the tribunal, we find that the relevant decisions on the point has been noted, and the case has been decided in favor of the respondent assessee. The issue being fully covered by the decisions.
Page 64, my lord, paragraph 15.
The decision of the Honorable Supreme Court in the case of State Bank of Patiala versus
South Indian Bank.
So just
Limited.
Citation.
It's just above 15, paragraph 15. That is, it's in proceeding now to another. That is the start.
State
The Punjab and Haryana Code 2017-88 taxman.
No. That is
State Bank of Patiala, my
South
lord.
Indian Bank is 438 ITR 1.
Huh?
South Indian Bank is 438 ITR 1. My lord will get it at page 63 of the ITAT order.
Yes. State Bank of Patiala was Patiala. What is the Supreme Court citation of State Bank of Patiala?
88, 393
No.
ITR 476.
That is 88 is Punjab and Haryana. Supreme Court.
Supreme Court.
You do a strike of that. Is covered by the decision in the case of the Honorable Supreme Court. In the case of South Indian Bank Limited versus CIT, 438 ITR page 1 within bracket SC. Thus, the tribunal rightly answered the said issue in favor of the respondent assessee. In the result, the appeals filed by the revenue are dismissed and the substantial questions of law.
My lord, State Bank of Patiala, my lord, was a Maxop case. My lord, that was a consolidated. My lord, that is 402 ITR 640. My lord will get it at page 61. My lord, that's it. My lord.
Maxop, I saw that. State Bank of and Maxop Investment, MAXOPP Investment Limited versus CIT 402 ITR 640 within bracket SC. Appeals filed by the revenue are dismissed and the substantial questions of law are answered against them. 5 I have said in the top. First paragraph. Hello.
Under heading application adjourned, serial number 11 and 12, Principal Commissioner of Income Tax, Central 2, Kolkata.
Yes.
Well, this matter relates to undisclosed income. Well, kindly come to my memo of appeal, which is in page 62. The tribunal is urged to hold that undisclosed income under the disclosure petition made during search and seizure proceedings as taken to book subsequently does not attract penalty. Then kindly come to page 3 of my petition, state petition. The assessing officer passed penalty order under section 271 AA-B of the Income Tax Act on such and such day on the view that the value of stock difference clearly represent undisclosed income coming under the purview of explanation to section 271 AA-B as it was not recorded in the books of accounts or before the date of search it was seen in the assessee submission that the stock was taken on such and such date and the valuation of the stock was taken on such and such date to be found at 6 crores such and such amount. Then kindly come.
नहीं दिया हुआ नहीं आप दिया नहीं था आप सर्विस में किया था
The ITAT order at page 45.
Yes.
The relevant portion is at page 55.
Lord, in this connection, if I may respectfully, the paper books which were filed before the tribunal, which are relevant to these dates and all and documents, perhaps they were not given. So
you file
those paper books.
You can file a compilation.
Compilation. That is what I am doing.
It is ready.
Ready.
You serve copy on
that's what, Lord.
And you file it in the next hearing date before us. Let it remain on your file. You serve copy, let them go through.
Because in this, my cross appeal is about.
He filed also a cross appeal, which is also on the list.
The learned senior, Mr. Murakal, and I heard so also. Mr. Murakal and senior advocate appearing for the cross objector, respondent cross objector. No, assessee / cross objector submits that that a compilation has been made ready consisting of all material papers which were placed before the learned tribunal and a copy of which has been served on the learned standing counsel for the appellant who seeks time to get instruction. Let the paper books be filed before the court on the next hearing date, matter to appear in the monthly list of May. Next.
Under heading for admission, serial number 13, Principal Commissioner of Income Tax 1, Kolkata.
But I'm not reading this one.
Hey.
So Rai is leading me, Milord, in this matter. Please come in.
Where are your questions?
Milord, questions, Milord.
Page 2.
Page 11. Milord, page 11. Lord. Paragraph 7.
The other day itself I suggested, no, you make it either the last paragraph or the first paragraph. It is always better before the prayer you make the last. How long you will take, Mr.
I'll take some time, Milord.
This sometime business is what is. It is like that other matter which we have reserved judgment. Lord, the facts were clumsy there. No, it is not so.
That's very easy.
Facts are very, very easy. It is the tribunal which made it clumsy, but I won't say that you made it clumsier. No, I'm not saying that. But tribunal wrote again and again and again and again. And these two remand orders, facts are very, very simple. Protective, this 12.40, whether it could have been added up.
But I had to place the facts before your lordship.
But one good exercise I think our tribunal has done was, why it became more clumsier was, it went into the merits. After holding this, it could not have, because the Chawal has got struck off, etc. He could not have made this addition, could not have revised, etc. Then he says, then he has proceeded. I was reading through the papers. It's not clumsy at all. He'll have it some other days because Lordship has got another DB at 3:30. As jointly prayed. List on souls. You give a date, sir.
Principal Commissioner of Income Tax 5, Kolkata.
Lord, I am appearing for the appellant.
Your Lordship, in this matter, I'm putting for an accommodation, Your Lordship. If it can be taken up next week, Your Lordship.
You want a compilation?
My Lord.
Heard Mr. Prithu Dorial and Prichis Junjunwala, learned advocate appearing for the respondent, seeks time to file a compilation. Let the compilation be filed and served on the learned advocate. For the appellant within 2 weeks.
It has been served, Your
It
Lordship.
has been served, my lord, compilation.
Has been filed a compilation.
It is not taken on record, Lordship. I can file it.
And request time to argue the matter. List the matter on
17th, Your Lordship.
17th April.
I'm grateful, Your Lordship.
Grateful.
Principal Commissioner of Income Tax 1, Kolkata.
My lord, I beg to appear for the respondent.
My lord, the issue involved is section 40 IB 10. So the section provides that if any construction is made after 1st of October 1998.
80. Section 80 IB.
80 IB.
40.
Then the assessee will be entitled to get deduction. If the construction is prior to that, the assessee will not be entitled for deduction. This is the issue involved here. Here, admittedly, my lord, the plan was sanctioned in the year 1993. Thereafter, there were certain litigations. Please.
But this 80 IB, once it is allowed, it is to be allowed consistently.
My lord, grateful. Grateful, my lord.
This appeal filed by the revenue under section 260 capital A of Income Tax Act 1961, within bracket the Act, is directed against the order dated 13th May 2022, passed by the Income Tax Appellate Tribunal, C Bench Kolkata, within bracket Tribunal, in ITA number 2256/KOL/2019 for the assessment year 2011-12. The revenue has raised the following substantial question of law for consideration. Page number 8, question number 4 alone. We have heard Mr. Amit Sharma, so and so, so and so. The short issue is falls for consideration in the instant case is whether the Commission of Income Tax Appeals was justified in allowing the deduction claimed by the assessee under section 80 capital I capital B of the Act, which order was affirmed by the tribunal. After going through the facts of the case and perusal of the order passed by the tribunal, we find that consistently such a deduction has been allowed, and the first year in which it was allowed Was the assessment year 2003,
2003,
4?
3, 4, 4, 5 and 5, 6, my lord.
3, 4, and thereafter, the assessing officer, after due verification, has allowed the deduction for in the assessment years 2004, 5 and 2005, 6. Thus, the deduction having been allowed in the initial year, the revenue cannot deny the same in the subsequent years. Full stop. The tribunal rightly noted the above legal position and also the decisions on the point, and therefore we find no grounds to interfere with the order passed by the tribunal. Accordingly, the appeal fails and is dismissed. Substantial question of law is answered against the revenue. Next.
Grateful, my lord.
Yes.
May it please, your lordship. Last occasion, my lord had condoned the delay in this.
16, Principal Commissioner of Income Tax, Kolkata.
This is, my lord, a penny stocks matter. The only difference is that 260 jurisdiction has been exercised. And
What is the
amount
tax?
of tax is
Subject to my learned senior friend, my lord, Mr. Mitro, my lord, the tribunal relied order of Uma Devi. Tribunal relied the order of Uma Devi. Your lordship, my lord, in my matter, last my lord, week, my lord, Uma Devi, my lord, answered in favor of the my lord revenue.
It's Usha Devi.
Oh, sorry, Usha Devi, my lord, sorry.
Maybe it's otherwise, yes.
Surana appeared.
Yes.
How will you get over this?
Yeah,
your lordship, the tribunal in my respectful submission did not rely on Uma Devi. I will
Usha Devi, sorry.
Usha Devi. Your lordship, I would draw your lordship's kind attention to paragraph number 11, which is on page number 41.
But your lordship, before that, kindly take paragraph number 10. Fully relying upon the Milord, Usha Devi Milord, ITAT number also been given Milord.
Page number?
Page number follow 30.
30.
30.
In fact, my lord, the tribunal has, my lord, gone on to, my lord, extract the entire judgment rendered on Usha Devi. And in the body of that judgment, my lord would also find Gitesh Tikmani,
Yes.
that is.
Usha Devi Modi
Yes.
versus ITO.
Yes.
Holy
Yeah. Your lordship, para 11, I would draw your attention to few lines. Applying the proposition of law laid down in the cases as extracted above to the facts of the case on hand. So, your lordship, this is not only Usha Devi. Usha Devi's case itself relied on number of judgments in support of the proposition that the order of the learned commissioner is erroneous or.
You file an appeal to the Supreme Court. Usha Devi, we have reversed the order.
Yeah, your lordship, Usha Devi's case facts were different. I would.
You have to go before the tribunal and say, sir, sorry, you relied upon Usha Devi. My facts are different.
And your lordship, it was not only Usha Devi, but two other decisions were there. And your lordship, in Swati Devi Bajaj, your lordship itself has observed that the facts of each case has to be considered on its own, your lordship.
Sir, you have missed the bus. You are not there when the matter was argued. We have heard days together. You passed a judgment. If you are aggrieved, you go on to Supreme.
And your lordship, one more point. On the basis of tax effect circular, the Honorable Chhattisgarh High Court had the occasion to consider the tax effect circular, where the tax effect circular was pointed out, which was issued in pursuance of this penny stock. After considering the tax effect circular, I would place before your lordship the judgment of Chhattisgarh. Retrospectivity is not an issue because no, not my lord. Tribunal was passed on 2021. Your lordship, not on the retrospectivity, but the Chhattisgarh High Court considered that in cases where organized.
We cannot test the order of the tribunal on reasons which have not been urged before the tribunal, not considered by the tribunal. The tribunal relied upon Usha Devi Modi. That order has been reversed. It's up to you to challenge it before the tribunal, or you should have gone before the tribunal and said,
but your lordship, in my respect,
because at that time, all of you were anxious only for your appeals to be allowed, not concerned about the facts. This is not, your case is not the first case in the batch. Several of your colleagues have argued like this. Sir, I went on to say this. I said, it's can't be 1.5 years, 2 years have gone.
Your Lordship, in my respectful submission, in my case, the assessing officer made threadbare inquiries. It is recorded in the order of the learned.
Go to, at least you go to Supreme Court against the order. None of them have gone to Supreme. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 is directed against the order dated 21st April 2021, passed by the Income Tax Appellate Tribunal C Bench Kolkata in ITA number 643/KOL/2020 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. Question number A, page number 4 and 5 of the stay application. A, D, and E. We have heard so and so. After elaborately hearing the learned advocates for the parties and carefully considering the materials placed on record, we find that the learned tribunal are allowed the assessee's appeal, fully relying upon the earlier decision in the case of Usha Devi Modi versus ITO in ITA number 874/KOL/2019 for the assessment year 2014-15 dated not assessment year, dated 12th January 2021. Against the said decision, the revenue had preferred appeal before this court in ITAT number 42 of 2023, which was allowed by judgment dated 30th March 2023. For better appreciation, the judgment is quoted here and below. Quote this entire order. The learned advocate appealing for the respondent assessee pointed out that submitted that the tribunal did not solely base its conclusion in the decision of Usha Devi Modi, but also took note of other decisions which were relied on in the said decision. On a reading of the impugned order, we find that in paragraph 10, the entire decision in Usha Devi Modi has been extracted. And in paragraph 11, the tribunal states that applying the proposition of law laid down in the cases extracted above, within inverted comma, the appeal of the assessee was allowed. The argument with regard to the manner in which the power under section 263 of the Act was exercised by PCIT was considered in the batch of cases, and a decision was arrived at in favor of the appellant revenue. We find thus we find that the decision in the case of Usha Devi Modi have rendered by the tribunal having been reversed by this court in its judgment dated 30th March 2023. We find that we hold that the said decision will apply to the case on hand, and consequently the revenue has to succeed in this appeal. In the result, the appeal filed by the revenue is allowed, and the substantial questions of law are answered in favor of the revenue.
Extremely grateful.
Thank you.
Grateful.
Seventeen, Principal
Right.
Commissioner of Income Tax Central, Kolkata 2.
May it please your lordship. 3 volumes stay petition, my lord. And there are as many as 8 substantial question of law that has been preferred.
That must be repetitive. We will reduce the 8 into 3.
Yes.
Where are the questions?
But there are three issues, my lord.
Sales tax subsidy covered, 14A covered.
Arm length price.
You show the questions.
Yes.
Page 7, my lord, page 7.
Page 7, 14A, written down value. This 43-1 also we did in one matter.
Lord, the assessee's own case, the batch of years had come up with my lords have dealt with it. This question was not admitted. Lord, but this one more. But the tribunal has followed that order, and a subsequent order, my lord, for assessment is 12-13 and 13-14. So, my lord, it will be better if the revenue tells my lords whether they have appealed against that.
They don't know. You please tell.
No, there's no service upon the assessee, my lord. There's no service. Otherwise, I would have.
See, at least intimation can be given through the AO.
My lord, that can be done.
Definitely, the AO will be sending mails, etc. In that one intimation, saying that appeal is being processed as against the order of IT number so and so.
That should be there.
So that he is aware. Because there's no provision to lodge caveat.
No.
So he will watch the proceedings in the cost list. So for those 2 years, you find out that
There's no
My lord, there is a tabulation, my lord, that has been reproduced in the tribunal's order itself. That, my lord, make the job little easier. If your lordship kindly have a
no,
look at.
if you have filed an appeal for 1213,
1213 and 1314.
1314, we'll club those appeals, we'll hear those appeals first.
That order is dated 20th February 2019.
There is, my lord, issue-based breakup, my lord, that is appearing at page number 376 of the volume 3 of the stay applications. Wherein, my lord, the tribunal had, my lord, gone on to, my lord, categorically observe, my lord, the issues which has been covered by the earlier case of the assessees.
Page 300?
Page 376, starts from page 376 and 377. There is a tabulation done by, my lord, the tribunal itself.
First issue.
Yes, first issue is
43-1. They say it is covered by 1213, 1314.
And even the earlier order also. The earlier order also. Both the orders.
3-4 to 11-12.
Yes, my lord, this is with regard to that period, but my lord, the order, my lord, which my learned friend has just, my lord, handed over to your lordship, possibly, my lord, is covering that period.
Yes, but this is the first order of the tribunal, the batch of years. And look here, my lords, were please not to admit this question. If my lords are pleased to take note, that was question E at page 2. And my lords dealt with this question at page 5. The third new paragraph.
Which is that question? Page 2?
Alphabet E, my lord.
E for elephant. Written down well.
And at page 5, the third new paragraph.
admit হয়েছে এটাই হচ্ছে
All right, so this will be, now let us go back to volume 1.
Yes.
Page 7. So first is written down value will be covered by decision in ITA number IT 8309.
Lordship.
Then what about 14A?
Not 14A, my lords are pleased to admit.
Has got admitted.
Kindly take note page 3 of this order. H and I, my lord. H and I. And then note page 5.
Oh, this is strategic investment, not
Yes.
that to rule 80.
Yes. Not in our year, that strategic investment is not there, but in any case, not page 5.
All right. B is admitted.
I'm not just one aspect. But there, my lords were pleased to grant the assessee leave to file cross objection because this was admitted. So in the previous order also, my lords were pleased to grant that leave to file cross objection.
Then B and C admitted.
B and C admitted.
Then what about D?
No, this corporate guarantee note, they had not taken a ground note in the earlier year, and that is why I was interested in knowing whether they've taken a ground in the 1213 and 1314. Because not if they have accepted there. Now in intervening year, if they've accepted, then I could make that submission that it's a closed chapter. Because they are only on the rate. It is not.
What is question D, sir? That's corporate guarantee.
Yes, corporate
D and E.
Corporate guarantee one.
D and E.
Then what is this adequate comparability analysis?
No, D, E, F and G, they're all relating to this addition for corporate guarantee. The tribunal said in principle the addition has to be made. The tribunal determined the rate as 0.5% in the earlier years, which been followed here. The revenue has been insisting for 3%. So whether it should be 0.5 or 3% is the question. But basically, it's that.
Then HIJ.
80I, this is
Which is adjustment by TPO for specific task.
No, this is that, there's a power generating unit, which transfers the power captively, to another unit. So, the valuation of that power, that was the question. In the earlier year, the tribunal had considered various decisions and sent the matter back. Therefore, my lord, so please not to admit that appeal because the question had gone back. And that is the order, which is followed here.
Question A. Question A, question B.
All right, will you please verify whether any appeal has been preferred for 2003-4, not 3-4.
12, 13 and 13.
12, 13 and 13, 14.
Yes, the particulars are at page 376, internal page 3 of the tribunal's order. Roman 2, those are the particulars.
We have heard so and so. In the assessee's own case for the earlier assessment years, namely 2003-4 to 2011-12, in ITAT number 309 of 2017, some of the substantial questions of law which have been raised in this appeal were not admitted and some were admitted. However, in respect of substantial questions of law number D to F, D to G, as suggested by the revenue in the instant case, the tribunal had followed the order passed by it in the assessee's own case for the assessment years 2012-13 and 13-14. The revenue is directed to get instructions as to whether any appeal has been preferred as against the said decision.
But they followed also the previous order. Previous order, there's no appeal, we know, but the intervening years, we need to.
When 24th. 24th. So then we will say 14A alone, we can admit club along with it. List on 24th.
I'm grateful.
Grateful, man.
Principal Commissioner of Income Tax 5.
This is my application, my lord. There is no section 5 application.
How many days delay?
No section 5, my lord.
Therefore, your
Question-
appeal should be admitted.
Yes.
No section
Page-
5. For
Page
once,
4.
What is this? 263?
Yes, 263.
Let
my
us
lord.
see what is
Yes.
the reason.
The reason is the case was selected for the limited scrutiny and with the parameters that your lordship, unsecured loans from the persons who have not filed their returns. Now, your lordship, if your lordship kindly comes to page 10, it's the order of the 263, but page 11 is the show cause notice, which has been extracted from the show cause notice itself, your lordship, and page 12 is the answer of the SSC, the response to the show cause notice. But there is their first point they have taken that there was no inquiry and there was a lack of inquiry. Number one, because relying on that Malabar Industries are the twin conditions, your lordship. But they are saying that they have submitted all the names of those unsecured loan creditors, but that doesn't match because there was an inquiry made, and based on those inquiries, the CIT was not satisfied and invoked 263, my lord. So from the assessor's letter, it does not transpire that any kind of investigations or the inquiries were made and they were able to satisfy the assessing officer with regard to those unsecured loans.
But the fact remains the limited scrutiny was on the ground.
Only
that
for
those
the unsecured, if, whether they have filed their returns or not.
But if you come to page 29, para 10.1.
Yes, it's
Acknowledgement of-
quite damaging, my lord. It's quite damaging, and that the tribunals arrived at finding that
This appeal, sir, this is previous matter, this order. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 31st October 2022, passed by the Income Tax Appellate Tribunal C Bench Kolkata in ITA number 100/KOL/2021 for the assessment year 2015-16. The revenue has raised the following substantial questions of law for consideration. Page number 4, question A and B. We have heard Smita Dasde, learned senior standing counsel for the appellant revenue. The short issue which falls for consideration is whether the Principal Commissioner of Income Tax was justified in assumption of his jurisdiction under section 263 of the Act. The case of the SSC was selected for limited scrutiny on the ground that they have availed unsecured loans from persons who have not filed their return of income. The assessing officer had issued notice under section 142 within bracket 1 of the Act and called for information from the SSC and having been satisfied with the same, completed the assessment. The PCIT invoked his power under section 263 of the Act on the ground that the assessment, the order of assessment is erroneous and prejudicial to the interest of revenue. The learned tribunal has elaborately set out the factual position and has ascertained that all the loan creditors have filed income tax returns and acknowledgement was produced and placed before the tribunal. And several of them have been assessed by the department and not treated to be shell companies. Shell, S-H-E-L-L. Thus, after having noted this factual position, the tribunal rightly placed reliance on the decision of the Honorable Supreme Court in Malabar Industries Limited versus CIT 2000-243 ITR 83 within bracket SC and granted relief in favor of the SSC. Furthermore, a chart was produced before the tribunal where the SSC has submitted all relevant details and substantiated the same with documentary evidence, which once again the tribunal found, from which once again the tribunal found that those persons that all the unsecured loan creditors have filed their return of income, their identity was established from the loan confirmation letters and the screenshot from the MCA portal, and for their creditworthiness, audited financial statements and declaration of source of funds for by way of bank statements were placed on record. The learned tribunal notes that the department was not able to produce any material on record to controvert the factual position which was established by the tribunal. Thus, we find that the tribunal rightly granted relief in favor of the SSC and the order does not call for any interference. Accordingly, appeal fails dismissed. Substantial questions of law are answered against the revenue. Next, 21. Yes.
Item number 21, Umesh Khemka.
Yes, Mr. Prasad.
For the respondents matter, my lord.
Very good.
Lordship, I appear on behalf of the appellant. Lordship, may I hand up my affidavit of service?
He's young man.
My affidavit of service. Lordship, if I may indicate, service on respondent number 7, 8, 10 and 11 is complete.
7, 8.
10 and 11.
He's here. Mr. Prasad is here.
Lordship, I am being led by Mr. Ghosh in the matter.
He's not present today.
He's on his legs, perhaps, Lordship.
But we have got another bench at 3:30. Another DB.
I'm appealing for the state respondent.
Would it be your Lordship's pleasure to fix it on Wednesday?
Wednesday.
Your Lordship doesn't take original side matter on Wednesday.
Wednesday.
My lord, I am appearing on behalf of the company, my lord. If a copy of the petition could be served on my
Lordship, the address which is appearing in the cause title, we have tried effecting service there. Very.
Or you make a photocopy.
Yes, I shall speak.
You're a company, he's an industry.
I shall speak.
Very
companies cost photocopy.
Grateful, Lord. We shall work that out.
Or Mr. Prasad will make copies for everybody. You are having so much of money.
Lordship, my grievance is not against the company. Just
against him. And what was the relief sought for in the writ petition?
I am praying for stay of the,
Recovery.
yeah. In this
my lord,
appeal, I'm praying for stay of the impugned order dated 24th of
so many
February.
criminal cases are going on, my lord.
That can go on. You can't recover anything.
My lord, here, my lord.
You are a director of the company.
No, Lordship, that's initially I was the manager finance. Thereafter, I was designated to be the chief accounts and audit officer.
And why they are prosecuting you?
That's
His name was here in the form 5. As a, my lord, maybe the owner,
Suppose he is a paid employee.
my lord, that was not the case.
And what is the
That's
interim
why-
order you sought for?
Well, the interim order that was subsisting was not to prosecute in the criminal proceedings against me.
Huh.
Well, kindly also,
So it got vacated.
but the writ petition was dismissed without even calling for an affidavit from the Provident Fund authorities. Now, my lord,
I have filed my report.
no,
As per
report
the
is not an affidavit.
Report in the form of an affidavit that was.
No,
filed.
this is not an affidavit on record. My lord, kindly appreciates one more thing. My lord, this company, a scheme has been formulated by this honorable court.
Right, Wednesday we'll hear.
My lord,
My lord, I am concerned with the money, my lord, 5 crores 24 lakhs is.
he is
refund
getting
payable.
payment under the scheme from the receiver.
My lord, 1 lakh or 2 lakhs per month, my lord, that will take.
Very good.
Company is to run certain payments per month made to the special officer who will pro rata distribute all the creditors including the provident fund.
Very good.
So that has been done by the special officer as per the direction of the scheme. I am only present to apprise your lordship.
Despite that, an employee of the company, yes, my lord.
If the special officer has been appointed, you cannot prosecute.
Yes.
But my lord, the later on, special officers were, my lord, appointed by this court, not before that, the period.
Maybe, but now you keep the prosecution in abeyance. You file your affidavit.
But my lord, lordship can says, my lord, I'll be.
All right.
I'll be bound.
We have heard the learned counsel for the
Lord, I
party.
was appearing for the company, but I have also made submission that it is, Lord, the company is functioning under the scheme by the division bench.
Since the learned writ court had disposed of the writ petition without calling for affidavits, and considering the factual position involved in the matter, we are of the view that affidavits are required to be filed by the parties. Initially, during the pendency of the writ petition, the appellant had the benefit of an interim order by which the respondent organization was restrained from initiating or proceeding with the criminal prosecution initiated against the appellant. Let that said interim order, which was in force till the writ petition was disposed of, shall continue till further orders in this appeal. The parties are the concerned parties are directed to file their affidavits within a period of 3 weeks from the date. Reply, if any, by whom?
Opposition, I will not reply by them.
The state government has nothing to say in this matter. We have been made party by the company.
You be there to assist us. Yes, so special
My
officer
lord,
is there.
your lordships are, my lord, restraining us, my lord, from proceedings. But one thing, lord.
It is like thing, you cut a goose, you don't get golden eggs.
I'm not there,
You
my lord.
don't get golden
What
eggs.
I want is this, my lord. My lord, 5 crore, my lord.
Lord, I am the hen.
I want
5 crore, put your claim before him.
Well, here the question is, I am the hen.
We
He is
want
not been able to cut me
enhancement
because
of-
I'm,
We
this
want
is the problem.
enhancement of the figure, my lord.
Let the affidavit be filed by the concerned respondent within 3 weeks. Also. Reply if any, but 2 weeks thereafter. List the matter in the combined monthly list of June 2023.
Oh, deeply obliged, my lord.
I request my lord the appellant for a copy.
Yes, I will serve. I will serve.
The learned
I've already
advocate for
given
the
to the
appellant shall serve copies on all the learned advocates for the respondent. Only 1 month.
Receiving payments under scheme, my lord, prosecute a poor accountant
Very meager
for 20
amount,
years.
Yes. Next.
1 lakh or 2 lakhs, not
22 lakhs of interest privately paid.
Please, my lords, I am appearing for the appellant. There's a delay of 9 days.
You have heard Mr. Pranit Bag, learned advocate for the appellant,
And
and
the
Smita
respondent.
Daste. There's a delay of 9 days in filing this appeal. We are satisfied with the reasons assigned in the affidavit filed in support of the petition, and accordingly, the application is allowed. Delay is condoned. Let the appeal be listed for admission on Wednesday.
Monday, my lord.
Monday.
Deeply obliged, my lords. May I, my lord, file the affidavit of service?
Affidavit of service kept on record.
Deeply obliged, my lords.
1 minute is there. Lordship will- You're flying from